Gavin Newsom's Executive Order N29-20, dated March 17, 2020. This meeting is being conducted via WebEx. Public comments will be heard for each agenda item for individuals wishing to do so. In order to be ready for public comment, we ask that you please ensure your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you have difficulty hearing the audio of this meeting using your device's audio, please click the ellipsis button at the bottom of the WebEx application or the Communicate menu item at the top of the WebEx application, and then select Audio Connection. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will still allow you to participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. President Lawson, you can now start the meeting.
Thank you, Sean, and good afternoon, everyone. I'd like to ask us all to turn our devices to silent and also have everybody on mute so we can all hear each other. Since this meeting is being conducted via WebEx, I will ask that board members and speakers alike please announce your name when you begin speaking, just for clarity of the official record. And all board members should be able to unmute yourself automatically in order to speak during the meeting. And you can also use the, I think, the raise hand feature as well if you'd like to get my attention. But please place yourself back on mute when you're not speaking to reduce background noise for all participants. Following this online meeting etiquette will ensure the best audio quality for everyone. During each call for comments from board members and speakers, we will ensure that all comments are and can be accommodated and are heard before we proceed with the agenda. Government Code Section 11126.5 does allow a board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. We do have a designated time on the agenda for public comment, and we'll ask for public comment on each agenda item. This is an official business meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. The board welcomes public comments on any item on the agenda, and it's the board's intent to ask for public comment prior to taking board action on any agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of the WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicated they wish to make public comment by name. When called upon, the host will unmute the microphone of the individual and they will each have 3 minutes to make their public comment. The host will audibly announce when 15 seconds remain to conclude the public comment. And after the 3 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. And please do see page 4 of the agenda for WebEx instructions on how to connect from the link on the agenda and additional instructions that may be helpful. I also want to add that we appreciate your patience with us as we operate this WebEx board meeting. I know from managing the past meetings that sometimes the comments can be tough to get into queue, or that it can be difficult to navigate the WebEx platform. So we thank you for and appreciate your patience. With respect to public comments on items not on the agenda, which is agenda item 2, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each public comment period. And then after 20 minutes, no further comments will be accepted. Again, each person will be limited to 3 minutes per agenda item. The board's IT staff will be assisting me with receiving these public comments via WebEx during the meeting. And I'd like to remind all speakers to please stay on topic and please do try to keep your comments to the allotted time period or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we plan to end today's meeting by 5:30 p.m. I would like to now, at 2:09 p.m., call the meeting to order and ask that board members unmute their computers. Ms. Caldwell, please call the roll.
Mr. Brooks,
Here.
Ms. Campoverde,
Here.
Dr. Bonadev,
Here.
Dr. Hawkins,
Here.
Dr. Kraus,
Present.
Ms. Lawson,
Here.
Ms. Lubiano,
Here.
Dr. Lewis,
Present.
Dr. Mahmood,
Yes.
Mr. Ryu,
Present.
Dr. Thorpe,
Here.
Mr. Watkins,
Present.
Dr. Yip.
Present.
Thank you.
Thank you, Ms. Caldwell. A quorum is present. Board members, please mute your computers. I would like to remind the members again that we will be taking a roll call vote on all action items. Moving now to agenda item 2, public comment on items not on the agenda. And before I call for public comments, I would please ask that individuals making comments not discuss pending complaints, pending license applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and could lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board would request the public to address the board as a whole and not individual members. And again, please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and then decide whether they'd like a future agenda item on the topic. Unfortunately, pursuant to the requirements of law, no other action can be taken on the item at this meeting. Though this may seem at times like board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals and the board's mission. If you'd like to comment on an item that is on the agenda, please wait until we get to that agenda item. Comments at this time are only for items not on the board's agenda. And please do limit your comments to 3 minutes. I will now ask the host to call for public comments.
Thank you, Ms. Lawson. As Ms. Lawson mentioned, you can either use the Q&A window, or we are also testing out the hand-raising feature today. So if you respond back in either the Q&A window or raise your hand, I will do my best to call on you in the order they come, but we will get everyone called upon here. So first up, I have Hannah Ree. Hannah, are you there?
Yes, I am. Thank you. Yes, hello, medical board members. This is Dr. Hannah Ree of Black Patients Matter. We at Black Patients Matter thank you graciously for the opportunity to speak at the inaugural quarterly public stakeholders meeting. However, we feel that it was highly inappropriate to censure the public comments by stopping board members from speaking directly back to members of the public, such as ourselves, Black Patients Matter. As usual, the hanging judge, Lawson, exerted her white privilege to prevent board members from responding directly to stakeholders using the excuse of, I promised everyone we will finish on time, which was her personal decision and not mandated by any California state statute. What we like best about Ms. Lawson is that seeing her on camera allows us to appreciate her facial expressions and disdain for our group. You can observe how when we speak, Lawson purses her lips, pupils dilate, and her voice is curt, mean, white, and privileged. Another federal civil rights lawsuit against such behavior should not be surprising, as the board member Kimberly Kirchmeier was also sued and is no longer on the medical board. So do not worry, her turn is coming soon. Thank you.
Thank you for your public comment. Next up, we have Rosie Arthur's daughter. Rosie, are you there?
Yes. Can
Go
you hear
ahead.
me?
Yes,
Okay.
you can.
Thank you. I've been working with the medical board in some aspect or another since 1994. I've worked in the field of forensic neuropsychology. I've been an expert witness. I've worked in diversion programs in county clinics. I've had cases that became gold standards, etc., and in administrative and social security law. Now, so I have a lot of experience. I've been a researcher for 50 years. And there's a real problem because things are presented on your site that are not accurate. And when you're told that they're not accurate, they are not fixed. In 2015, I informed the administration of the board about such items, and they did nothing to fix it because it apparently supported certain special interest agendas and not the consumer. At least that's all that I can ascertain from what has not happened based on the evidence. Your board, I'm sure, is acting in good faith and only on what you're given, and probably the same thing for the staff. So when you have garbage in, garbage comes out, good data comes in, you get good data that comes out. There's more than one way to look at data depending upon how you prioritize it. So you can take one set of data that says A equals B and then C, and you get other stuff that says A equals Z from the same data, depending on how you define it. So one of the biggest problems that I've encountered in advocating for different people and populations has been there are inferences drawn that certain laws or statutes have been changed when they have not. References have been deleted from your website intentionally and left off. And then these beget other problems. So deviation becomes the norm. And the special interests are supported, and the consumer is the last one and is responsible for everybody else's wrongdoing, effectively.
30 seconds.
Now, okay, BMP code 2241.5, health and safety code 124960961, and BMP 2220.05, number 3, A3, those are not referenced. They're not used. And what that causes is patients with intractable pain, the people who have the least amount,
Please conclude.
the most vulnerable, are being adversely affected. So those need to be restored. Has nothing to do with new guidelines. Those should have been there all along. Thank you.
Thank you for your public comment. Next up, we have individual identified as W. Brannon. W, are you there?
Yes, I am. Thank you. Can you hear me?
Yes, please go ahead.
I was hopeful to see new board members. I hope that this board goes through regular Brown Act training. I would encourage that all votes are done by roll call as required for remote meetings. There was a sub-panel meeting this afternoon that adjourned without a roll call vote. And for those wishing to participate or observe, it's important to know how people vote. You are dealing with an enormous backload of cases. Some people have been waiting 1,549 days. Let me say it again, 1,549 days for a resolution before this board. I don't believe that and this was around 2017, with the current backload that you have, I don't believe that you can responsibly and in a timely manner, especially with the delays of the last year, handle cases currently only meeting 4 times a year. It's rather alarming. You have had a high turnover of staff. I know that some cases have gone through 3 different investigators and maybe 5 different case managers. And when you have that type of inconsistency with length of delay, the information that finally winds up in your lap is not always clear because the flow of information gets muddled. So I would encourage you, one, to look at your caseload, your ability to handle all cases in a timely manner with the attention that they deserve, and somehow address this deficiency of staff and the amount of time that it takes to resolve a case. 1,549 days, to me, is not acceptable. Thank you.
Thank you for your public comment. Next up, we have Sandra Perez. Sandra, are you there?
I am. Thank you. Good afternoon, everybody. My name is Sandra Perez, and I'm from Hesperia in San Bernardino County. I wanted to let you know, again, our daughter Jordan died at the age of 17 as a result of egregious medical negligence. I'm a victim of further trauma exacerbated by this medical board's multiple complaint closures for confirmed medical malpractice by the number of physicians and unlicensed students who I allege contributed to my daughter's death. Over a year after submission, I inquired with Ms. Jones about status, and shortly thereafter, the board closed every single one of my complaints without investigation, without contact, and then they further issued a license for a medical student deemed to have been practicing without a training license during my daughter's hospitalization in 2018. Ms. Shembra confirmed this individual did not hold a training license at that time. In 2019, I reported a lack of supervision, repeated negligence, and potential felony to this board and requested licensing information of these negligent residents. The board refused to provide their malpractice and discipline records on their initial full license application after my daughter's death. The board was dishonest and intentionally failed to disclose required information to me, and further continued their support of non-compliant residents practicing without training licensing from 2017 through 2019, all without zero supervision. This is also evidenced in my daughter's medical records, where this individual indicated he called in status reports to licensed physicians, where he represented to me that he was a licensed physician in violation of BPC 2054. Unlicensed residents are not allowed to call in status reports to licensed attendings. I would also like to respond to the board's views that postgraduate training licenses that came into play in 2020, that these holders possess no risk to the public. Under supervision, that may be true. However, there is no oversight or enforcement when it comes to supervision of PTL holders. In our daughter's case, licensed physicians signed statements saying they were present with the medical student when it was absolutely untrue. To add insult to injury, the licensed physician, after never seeing our daughter, said all of our daughter's tests were normal when they weren't. And because of no oversight, an inexperienced and unlicensed medical student sent our daughter home, indicating her condition of portal vein thrombosis was not life-threatening, and of which she died of liver failure 19 days later. The board never investigated this resident and continues to let him practice now with a license that you provided him. This is my main concern for patient safety in regards to the PTL. Thank you for your time.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, hello, good morning. Can you hear me?
Yes, please go ahead.
I should say good afternoon. I'm Susan Lauren. The Hunting Ground is a 2015 documentary about sexual assault on college campuses and the failure to deal with it. It resonates with me deeply, a victim survivor of surgical assault, and I recommend that you watch it. A victim in the movie said, quote, "I told this administrator I was violently raped, and she looks at me and she says, 'Rape is like a football game, Annie. And if you look back on the game, what would you do differently in that situation?' I was expecting resources. I was expecting support. And instead, she gives me this metaphor that rape is football. And it made no sense. And I was like, No, rape is not like football at all. I was just getting blamed and blamed and blamed for this. I thought if I told them, they would take action. But the only action they took was against me. There's a lot of victim blaming with this crime, which has a silencing effect on survivors." End quote. The media reports medical harm in cheap Tijuana clinics, but there's a wall of silence around privately owned ambulatory centers in California that are prime hunting grounds for predators. When people report harm by plastic surgeons in California, they're often threatened, gaslit, and called crazy. No matter what you do, you lose. I was not given consent to make an informed decision. I was scammed and violently assaulted. The medical board and defense lawyers use experts who are corrupt and lie profusely. They claim mitigating circumstances when there are none. My complaint is a clear case of battery. No one would know the truth by reviewing Berger's misleading records and photos or listening to him or his lawyer. The board didn't talk to my doctors and witnesses. I detailed the lies and omissions and was chastised by medical board staff for sending too much information. You tell us to create laws, but there already are laws against invalid medical procedures and assaulting patients, but you ignore them. Short-sightedness, ignorance, and malice drive plastic surgery. For the most part, there are some good aspects to it, but you know what I'm talking about. Medical boards and laws regulating medicine were created long before cosmetic procedures were contemplated, when doctors used to treat illness and disease. Destructive, unethical plastic surgeons with carte blanche fill this state. When there are new accusations, Thank you. When there are new accusations and you look up the doctors, you'll likely find a history of harm or lack of respect for life. And I already know about most of these people. They may risk life for no valid medical reason, and this isn't medicine. It's harming, not healing. Picking off seeds one by one does not protect the public from the orchard of harm and death. I've contributed a lot of information. I want to continue to work, but with you. I want to be respected. I want you to overhaul bad policies and procedures in order to protect Californians and therefore protect people around the world. Thank you for your time.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, can you hear me?
Yes, we can. Please go ahead.
Thank you. I appreciate the opportunity to comment today. I'm Kristen Ogden, speaking on behalf of Families for Intractable Pain Relief. Our topic is the urgent need to restore access to medical management for intractable pain patients. I want to also thank the acknowledgement given at the public stakeholder meeting in April by some board members to the concerns we raised at that time. We appreciated that. I want to really emphasize today the urgency of the issues we're raising and our commitment to work with the board to find solutions that can bring about the changes that these patients need. We previously have proposed the establishment of a certification and registration program that would allow medical practitioners to treat non-standard pain patients, intractable pain patients, safely and without fear of legal reprisal and with more flexibility than is generally available today. We now want to add a piece to our recommendation, and that is to consider establishing the registration and certification program as something along the lines of a demonstration project. Demonstration projects or pilot projects are common in government, and they are typically established to provide a means for experimentation and innovation to let people try new or unproven methods, and they usually include waivers of restricted policies and rules. We often hear from opioid opponents that there have not been sufficient long-term studies of opioid therapy to prove their safety and value. A demonstration could allow medical management of intractable pain to resume for patients who are suffering from loss of care, and also provide perhaps some information to contribute to filling in that gap between what we know and maybe what we don't know. I believe such a project could be set up and implemented quickly, and that it would not require much in the way of any budget from the medical board. The paramount doctor of intractable pain, Dr. Forrest Tennant, when he was in active practice, subsidized the operation of his clinic from personal funds to keep the price low for his patients. And he is again looking to subsidize clinic operations to treat intractable pain patients. I would think that it would be possible to put something in place And I think one way that I kind of look at that is that, you know, we have had a national emergency with regard to the COVID-19 virus, and we have emergency authority to allow the rapid establishment of vaccines and approval to deal with an emergency. I would simply stipulate that there is also an emergency with regard to the lack of effective medical pain care for these patients, and something needs to be done right away, and we would like to work with you on that. Thank you very much again for time to speak to you today. I appreciate it.
Thank you for your public comment. Excuse me. Next up, we have Eric Andrews. Eric, are you there? Eric, have unmuted your microphone. Are you there? Hear computer noises, so I'll come right back to you. And next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
Thank you. Good afternoon. My name is Marion Hollingsworth, and I'm a patient safety advocate. I would like to suggest that a future meeting address the new approach to enforcement that Executive Director William Persivka spoke about at the Sunset hearing on May 5th. He described a more effective and efficient enforcement process. There should be an explanation of what exactly this means for consumers. Advocates interpret this as effective and efficient approach as a scaling back of investigations in order to save time and money. Since the board's discipline rate is only 3.5% and cases take an average of 3+ years by your own figures, it would be helpful to explain how this new plan would ensure public safety. Also, I'd like to recommend that a future meeting have an agenda item on the early termination of probation. At yesterday's panel hearing, one of the attorneys mentioned that doctors given 3 years probation can petition for early termination in as little as 1 year. Since the board is frequently making stipulated decisions that don't follow the disciplinary guidelines, more doctors are getting as few as 2 or 3 years probation for egregious cases such as childbirth death, sexual misconduct, and surgical gross negligence. You should identify the statute and explain how early termination is in the best interest of public safety. Finally, I would like to make a suggestion regarding panel hearings. At yesterday's panel A hearing, it was surprising that 2 doctors commended a doctor for being brave enough to come before the panel. This was a physician with an admitted alcohol addiction, including a DUI for having a blood alcohol level of 0.29 when he was arrested. He wanted his license back with no more than a reprimand and no biotesting. It was surprising that these 2 panel members were openly praising this doctor's courage to come before the panel. I would expect that you would save your compliments for the privacy of the closed session when you are discussing the discipline. Perhaps you would consider having some restraint at your panels to at least give the impression that you're not biased and are doing your job to protect the public. Thank you.
Thank you for your public comment. And going back to Eric Andrews. Eric, are you there? Yes, we can. Please go ahead. 30 seconds remain. Thank you for your public comment. I had one Q&A request, someone asking about the raising the hand feature, and I know on different platforms it's in different places, things like that. So we're going to be taking both Q&A responses and hand raises today. Queue them up in the order that they come in. So please feel free to use whichever is easier for you. Okay, thank you very much. Go ahead, Ms. Lawson.
Thank you. Just to confirm, Sean, we don't have any other public commenters in the queue?
Correct. That was the last request. Yeah.
Great. Thank you. And thank you to all the members of the public who took the time to share your comments with us this afternoon. We're going to move on to agenda item 3, which is approval of the meeting minutes from the February 4th, February 5th, 2021 quarterly board meeting. Members, please do unmute your computers and let me know if there are any additions or corrections to the February 4th and 5th, 2021 board meeting.
I have an addition.
Dr. Kraus.
On page 37, future agenda items, the 4th agenda item suggested by Ms. Lubiano was also my request. So it would read Ms. Lubiano and Dr. Kraus requested an agenda item on cultural competency.
Great, thank you.
I move to approve the minutes of the February 4th, 5 quarterly board meeting.
Thanks. I have a motion. Yeah, one second. I have a motion from Dr. Lewis. Do I have a second for the motion? Then we can continue discussion. Sorry, who's the second from?
Mahmood.
Okay, motion and motion from Dr. Lewis and a second from Dr. Mahmood. And Dr. Hawkins, you've got a comment.
Yeah, just a couple corrections. Agenda item number 6, executive management report. Substitute the word better, BETTR, for bespoke. It should be better. And agenda item 22, presentation on enforcement process. Second page, third paragraph. Ms. Jones reviewed the formal investigation process, saying an investigator at HQIU will request, et cetera, It should read not just will, but will or may. And I'll send this to Ms. Caldwell.
Thank you.
You're welcome.
Any additional discussion or comments or corrections to the minutes?
Yes, on page 38, under future agenda items, should be to be for recruited.
Is that my line that's having trouble, or is Alejandra's line having trouble?
It's her line. I believe we're all experiencing the same thing.
Okay.
Can you hear me?
Yeah, could you please repeat what you said? You broke up there a little bit.
Yes, can you hear me now? Am I clear? Yes. I said that on future agenda items, page 38, edited to read, requested a presentation on how medical experts are recruited and trained. So we're added recruited.
Thank you. And then did you have a second part of that comment? Or was that second part of that correction?
No.
Okay, thank you.
That was all.
Any additional comments, corrections, or additions? All right, seeing none, I'll ask the host to call for public comments again on agenda item 3.
Sorry, I just got that cleared out. Let me open that back up. Anyone wishing to make a public comment, again, you can go ahead and use the Q&A window to just type yes or anything in there, or use the hand raise function, and we'll call on you in the order received. First up here requesting, we have Hannah Ree. Hannah, are you there?
Yes, thank you. This is Hannah Ree, Dr. Ree with Black Patients Matter. I would just like to suggest that I believe that public comments made during the meeting are not entered into the record. I would state that they are probably very relevant to the meetings, and that in some way it would be a benefit to have public comments entered into the record. So perhaps I may need to work with legislators on that. I don't know, but just wanted to state that. Thank you.
Thank you for your public comment. Next up, we have Rosie Arthur. Rosie, are you there?
Hi. Yes. Thank you again. I'd just like to comment on Dr. Ree's comments there about the minutes. The minutes have been woefully lacking for a long time at the board, and one way to fix that is to take the closed captioning text from the webcasts and just simply make a transcript. Then you would have the accurate basis for minutes. So for example, the stakeholders meeting, it has nothing to do with really what happened there. And there's nothing you can go by that. But if we had that transcription, then you would have your minutes very easily. I'm still waiting for the presentation on intractable pain that was supposed to be done in November, that we'd asked for in advance. 2 board members asked for it, and we did not get it. And it's been asked for the February. It did not happen. It was asked for this. It still has not happened. I do not know what the reluctance is when even your own board members ask for a presentation on intractable pain.
The comments are for this agenda item, corrections to the minutes.
Okay. All right. The other thing is, well, if you don't have these things in the minutes, then it's hard to correct something that isn't there. Proving a negative is different. So when things are missing from the minutes, that's a problem. The other thing is the right to know law. That's not functioning in bringing up the links to the cease practice orders on your website, so that when the public goes to see a doctor, they don't know that that person has a cease practice order, and these are being hidden from the public. I've notified your webmaster, but you folks need to know that the public can't access that information, that you're making enforcement actions, but the public is not being given them. Thank you.
Thank you for your public comment. At this time, Ms. Lawson, I do not see any additional requests.
Thank you, Sean. Given that we have a motion and a second on the table, members, please do unmute your unmute your computers so that we can have a vote. Are there any further comments or discussion from the board members? All right, Ms. Caldwell, please perform the roll call vote.
Mr. Brooks,
Abstain.
Ms. Campiverde,
Aye.
Dr. Gonadev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes, excuse me.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Yes.
Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Yes.
Thank you.
Thank you. The board meeting minutes from the February 4th and 5th, 2021 board meeting are approved. Members, please do remute your computers, and I will now move on to agenda item 4, the President's report. And it is my honor and privilege this afternoon to introduce our 2 newest board members that we will be swearing in here in a moment, Mr. Ryan Brooks and Mr. David Rue. Mr. Brooks was appointed on February 2nd, 2021 by Governor Newsom, and Mr. Rue was appointed on April 19th, 2021 by the Speaker of the Assembly, Anthony Rendon. Mr. Brooks is currently the Executive Vice President of Government Affairs for Outfront Media, responsible for creating and maintaining governmental and public affairs activities, compliance, community outreach, policy direction, and fundraising activities for the United States. Mr. Brooks' many appointments include an Industry Trade Advisory Committee on Services and Financial Industries under the Obama administration and reappointment under the Trump administration. In 2003, Mr. Brooks was appointed by San Francisco Mayor Willie Brown Jr. to the San Francisco Public Utilities Commission and reappointed by Mayor Gavin Newsom in 2004, serving as the Vice President in 2006 and President in 2007. Mr. Brooks served as the Director of Administrative Services for the City and County of San Francisco under appointment by Mayor Willie Brown Jr. Mr. Brooks was appointed by Governor Schwarzenegger in 2008 to the California Board of Pharmacy and reappointed in 2010 and 2016 by Governor Jerry Brown. Mr. Brooks is a former member of the New Motor Vehicle Board as well as the Little Hoover Commission, and he received his Bachelor of Arts degree in Industrial and Organizational Psychology from San Diego State University. Mr. Ryu is a former Los Angeles City Council member, ethics reformer, and community mental health care advocate with decades of experience in the City and County of Los Angeles, as well as in nonprofit management and leadership. He was elected in 2015 to become the first Korean American to serve on the Los Angeles City Council and the first Asian American ever to be in City Council leadership. In 2019, the City Council passed Ryu's landmark campaign finance reform bill into law, barring campaign donations from real estate developers with business before the city. And Ryu also introduced legislation to expand oversight in City Hall and create stronger checks on potential pay-to-play contributions. Ryu also led the city to launch Opportunity LA, Ryu's children's savings account program for every child in Los Angeles. Previously, Ryu served as the Director of Development and Public Affairs at one of Los Angeles' largest health and mental health care provider, Kedron Acute Psychiatric Hospital and Community Health Center. He also worked as a community activist and dispute resolution mediator in South Central and East LA, neighborhood council member and senior deputy to Los Angeles County Supervisor Yvonne Burke, working on issues of public health, mental health, housing, transportation, immigration, HIV/AIDS, senior services, and foster youth programs. With those introductions, I would like to swear both of you in today. Can you please raise your right hand and repeat after me? I, please state your name. Oops, I think I need to have you unmute yourselves.
Yeah, hi, Ryan Brooks.
Hi, David Rue.
Thank you.
Do you solemnly swear or affirm
Do
Do
solemnly
swear or affirm
that I will support and defend the Constitution of the United States
that I was
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will
that I will
bear
bear faith and allegiance
to the Constitution of the United States and the Constitution of the State of California,
to the Constitution of the United States and the Constitution of the United States, or State of California, excuse me,
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
without
any reservation or purpose of evasion,
and that I will well and faithfully discharge the duties upon which I am about to enter.
and I will well and faithfully discharge the duties which I'm about to enter.
Well, thank you, Mr. Brooks and Mr. Ryu. We are excited to have you on board. We're thrilled to have two additional public members. So thank you for your service, and we look forward to working with you and eventually to the opportunity to meet you both in person. Now, just for a very brief president's report from me, because we do have a number of items on our agenda where we're going to go into some detail and depth on some of the particular activities that I've participated in since our last board meeting. Of course, you already heard, and I think most of you were aware, that we did hold a public stakeholder meeting on April 12th. The webcast from that meeting is available on our website at www.mbc.ca.gov in the meeting section under the About Us tab. And we are going to have an update on this meeting later today. Later today, we'll also hear more about our sunset review hearings, which has taken up the bulk of my time as medical board president over the past several months. And so we'll hear about that in more detail later on in the meeting as well. I also participated in a number of meetings with parties. You'll hear about that in a moment from me, as well as in the recent Federation of State Medical Board meeting as the voting delegate on behalf of the California Medical Board. Are there any questions or comments by board members on the president's report or on the swearing in of our 2 new board members? All right, seeing that, I'm going to ask the host to please call for public comments.
Okay, the Q&A window is back up, and if anyone would like to make a public comment, indicate so in there, or again, use the raise your hand function. We'll call on you in the order received. First up, I have Eric Andrus. Eric, go ahead. Yes. Thank you for your public comment. Next up, we have Hannah Ree. Hannah, are you there?
Yes, and so as a Korean American myself from Los Angeles, what we just experienced from Eric Andrus is cultural insensitivity and a little bit of ignorance. So when you are Korean American in Los Angeles and you advocate and you mediate in places like East LA, being accused of things is part of the job. So obviously, Mr. Davis was not found guilty of anything. The charges were dropped. They were never refiled. So I just want to state and remind everyone that for myself, being a Christian, I realized a long time ago that people have faults. I personally am not embarrassed, and I don't believe our local government is embarrassed by having a mediator, advocate, Asian American, trying to mediate East and West LA, being accused of something, not found guilty, and not having charges refiled. You know, look, I'm revoked. I'm not embarrassed. I'm here. I know how the system works. And then also this question of him taking inappropriate money from real estate. Who knows the details? I didn't find anything about him being found guilty. So innocent until guilty. I'm not embarrassed. I don't think our government's embarrassed. But anyway, so this is an example of what happens when you're a Korean American trying to be a mediator, graduated from UCLA, going into mental health. Obviously, when you're working in mental health, you're not dealing with healthy individuals all the time. So just wanted to point that out, that when we don't work in areas of racial diversity and religious tolerance, these are the kind of comments that we hear from white privilege. Thank you.
Thank you for your public comment. At this time, those are all the requests I see in queue.
Thank you. We'll move on now to agenda item 5, board member communications with interested parties. And I'll ask if the board members have anything to report. Members, please do unmute your computers if you wish to speak.
I do. On
Dr. Kraus.
On April 27th, I received a email from Vanessa Kajina of a lobbying group representing the California Academy of Family Physicians, asking to speak with me regarding their concern on the postgraduate training license. And we subsequently had a call and discussed their concerns regarding moonlighting and leave concerns within the 36-month licensure period. That's it.
Thank you, Dr. Kraus. Any additional?
Madam Chair, Dev Ganadev, as usual, I can tell you that I am actively involved in politically with anything related to healthcare. So I do communicate, but we do not ever talk about the medical board. I keep that separate in my mind.
Thank you. Any other board member communications with interested parties? So I do just have a brief list to report. I did meet with Senator Caballero and other parties that have a particular interest in the Mexico pilot program. I did receive correspondence and communicated with patient advocates about the stakeholder meeting and other other comments, but not anything about discipline or license applications before the board. I spoke with Bridget Grammy from the Center for Public Interest Law, and I did also meet with representatives of the California Academy of Family Physicians, the California Medical Association, the California Primary Care Association, SEIU California, and the American College of Emergency Physicians California chapter regarding their comments about the PTL license, which have also been expressed during the sunset review process. So is there anyone else who has communications with interested parties to report?
Dr. Hawkins, I apologize.
Dr.
You reminded me. I did speak actually twice with Bridget Grammy of the Center for Public Interest Law about our committee, Public Outreach Education Wellness Committee, and discussing how we may work together along with other stakeholders to improve communication responsiveness of the board to the public.
Thank you, Dr. Hawkins. Any other communications? All right, seeing none, I'll now ask the host to call for public comments.
Okay, again, the Q&A window is open, and be looking for those raised hands if you'd like to make a public comment on this agenda item. First up, we have Rosie Arthur's-daughter. Rosie, are you there?
Yes, I am. I'm sorry, I actually had my hand raised for the last one, but the person I assist 24/7 needed my immediate assistance, so I had to step away. But communications with interested parties. It doesn't happen. Back in 2015, I had communications with Kimberly, and supposedly things were supposed to happen. They didn't. I've contacted the board numerous times in between. Oftentimes the communication doesn't go to whom it's directed to, it goes to somebody else, or the answer is non-responsive to the question. And I was promised back in November that I'd be able to speak with the new board president to go over some of the issues, and she's local to where I am. And instead, you know, nothing happens. It's directed to somebody else. And, you know, I can't write volumes and volumes and volumes only to know that nobody is reading it. There's evidence and things can be fixed. There's lots of problems, they can be fixed. But if you don't communicate, you know, especially people who are interested enough to keep communicating with you, it's a problem. So I would like to have an opportunity to speak with the board president like I was promised in November, and maybe be able to show how important some of these issues are. And I'm a forensic person. You know, facts are facts. And when these are ignored, like I said, deviation becomes the norm. And other groups end up taking over what is your presence of authority. And when that's capitulated, everybody loses. Anyway, thank you very much.
Any public comment? At this time, I don't see any other requests in the queue.
Thank you, Sean. We will move on now to our next agenda item, which is agenda item 6, executive management reports. Mr. Prasivka.
Madam President, thank you very much. You have the reports. I will go through first to item 6A, which is the administrative summary. Just to begin to state that the last period since the previous board meeting has been an extremely busy time for the executive. Obviously, we have had a huge amount of work to do in terms of the sunset process, and more about that later. We've had Senate confirmation of 4 members who were successfully confirmed by the Senate Rules Committee just this week. We've had a lot of discussions, and we will speak about that separately, about the postgraduate training license, meetings with the Mexican pilot project, and then, of course, we had everything of business as usual. And so I want to thank my staff for putting in a huge effort. Many board members would have seen communications from them at all hours of the day or night, and it's been a very busy period, but we're happy that we were able to bring a number of projects to a successful conclusion. Moving on in terms of the staffing update, you'll see that we have 8 new employees since 2001, since February 2001. Again, a very busy time for our administrative unit there. The budget update, again, we have shown some marginal improvement in the budget outlook, particularly compared to what the projections were in January of 2020. This is due because of operational efficiencies as well as increased projections in revenue. So we are trying to operate efficiently and effectively within the envelope of our resources, but this does not obviate the need for a fund for a fee increase, which we believe is long overdue. But there will be a separate presentation tomorrow in relation to the budget. In terms of waivers, you will see there that there have been a number of waivers in relation to the rollout of the coronavirus vaccine, and those are all listed there. In terms of the external communications update, again, we had mention of the public stakeholders meeting, which was held, and in fact, we have a separate item to talk about that. The board published its winter 2021 newsletter. We had lots of communications in relations to the temporary COVID-19 waivers and vaccine eligibility rollout. One item which is of great concern to the board and to the executive, and has been for a long time, is that there are some very sophisticated scams which are being perpetrated by fraudsters who are extorting members of the public purporting to be employees of the medical board. Now, we have worked with all relevant authorities. We have made all notifications, both within the DCA family, as well as internal enforcement agencies. We put a number of communications up on our website and on social media, but these scams continue, and it's a source of concern, and we will remain active in this area. We have the remote working update, and again, the board has fully complied with all state rules in terms of remote working and encouraging that wherever possible. However, at this point, we are looking forward to the time when there will be a rollback on remote working, pending, of course, direction from the governor, and we are working so that when that day comes, that we will be prepared, but we're determined to make the rollback as seamless and as less disruptive as possible to staff. We have information updates about the information systems branch. We're redesigning the physician survey to make it much more efficient and make it user-friendly. We're trying to operate more efficiently and effectively by printing your own pocket license cards and notice to consumer signs and QR codes. And we continue to work in terms of the rollout of the Docs portal, which is a very important initiative which began at the start of COVID and is a drive to make our licensing process as efficient and as seamless and as online as possible. There's updates about our interagency agreement in terms of the authentication of licensees, our website refreshed in terms of ADA compliance, and that we have over 2,000 documents that have been passed for remediation to make it ADA compliant. We've redesigned our complaint form, and we've had further WebEx training for medical board experts. What I would like to do is to move on to item 6B, which relates to enforcement. Again, the expert reviewers program goes to the heart of enforcement, and we have actively been searching for additional experts, expert reviewers. That is all set out. We continue to make progress in terms of the processing of complaints. Again, efficient and effective enforcement is our goal. Well, we're asked, what exactly does that mean? What it means is that each complaint is handled appropriately. We hope that the less serious complaints can be dealt with swiftly and effectively. Where remediation is required, it is initiated at the earliest possible date, and that those cases which are more serious, which have a much greater impact on patient safety, that they are given more resources and more attention, and that we push those to achieve the type of disciplinary action ultimately which will be required. Now, if you look at some of the outturns that have happened, we have, particularly in the last quarter, been meeting and exceeding targets in the times to initiate complaints. They're now down well under 10 days. They're down now to 6 days. We have made a concerted effort to both monitor and identify our complaints, our communications with complainants. We have introduced auditing of that complaint communication. The results of that are set out in page 2 of the memorandum. And frankly, we have identified that we have to do better, that we will develop better templates, more milestones. We will continue to monitor communications with complainants. We will continue to audit that, and we will ensure that we will be meeting and exceeding targets that many of the board members, particularly recently in their confirmation hearings, have said are so important. The executive is dedicated to making the complaint process more user-friendly, more complainant-friendly, to try and be more supportive. And we have a number of initiatives which we can detail on that. They include random audits. They also include, as we have said, we're working to develop a complaint tracking system for those individuals who have filed a complaint so that they can look at online where their complaint is and be notified of various milestones. And we'll continue to undertake other kinds of activities, as we will mention in response to the stakeholders, to the interested parties meeting later on. There's information in the report about the operations of the Complaint Investigative Office, about the DCU unit, the probation unit. The probation unit is now fully staffed and has made great progress there. I would like to draw particular attention to some of the charts which follow the memorandum on enforcement. Chart 6B5 in terms of complaints received. Remember, that's only 3 quarters. There's 1 more quarter to go. So it does indicate that we will be on track to receive in excess of 10,000, perhaps close to 11,000 complaints. Just to make a note, obviously the past year, COVID has been very disruptive. It's been very disruptive to the practice of medicine. There are certain parts of the medical fraternity who have been overworked, and there have been other parts of medicine which have been very much reduced in activity levels. That has got to have that disruption, the transformation of activity levels has to at some point translate into different numbers of complaints and different types of complaints. So we'll have to monitor that very carefully, but we would hope that in the next year, we may see a different number and character of complaints than we have had as the nature of the practice of medicine returns to what it was pre-COVID, we hope. Moving on in terms of the complaint initiation time frame, that shows again that we have made great progress in terms of reducing that timeline, just as well in terms of the average days to initiate complaints in the central complaint unit, that has been reduced as well. I would now like to turn your attention to actually the last document in the enforcement package, which relates to a tracking of the total number of complaints that we have, as well as the aging of complaints. Now, just to refresh the board's recollection, we first brought this pending enforcement caseload summary at the November meeting. And then we had a February meeting, and now we have the meeting in May. So we have 3 sets of numbers. In the most recent period, we show a reduction in the total complaints in the system of pretty much close to 6%. Now again, the goal here of the executive is not simply to reduce the number of complaints we have in the system. No. The goal is to manage them effectively and efficiently so that less serious complaints are closed efficiently, quickly. Where necessary, remediation is brought in as quickly as possible. It is by doing this that we can devote more time and more resources to the more serious complaints. Where we can reduce the number of complaints, it does show to me that we are achieving results in terms of closing the easy complaints efficiently. We're particularly working on getting the aging profile down. So those cases which have been in the system for a longer period of time. And it shows that under existing resources, we are keeping abreast of the complaint flow, at least in one important metric. Now, if you actually compare the numbers of cases in the system from May to November of last year during those 6 months, it is down approximately 13%. It is the hope that ultimately that will translate into reduced activity levels coming both from the Attorney General's office as well as the HQIU. The most recent figures indicate that the numbers in HQIU are falling. Again, with those activity levels going down, we hope to see some cost savings. I don't need to remind the board of our difficult financial position. We're doing everything that we can to operate within that. And what we're trying to do is to transfer resources from the less serious complaints to the more serious complaints. I am grateful to the staff for having made significant progress. We have a lot more progress to make, but I do think that there's some indication that we are on the right track there. Moving on to item 6C, which is licensing, just very quickly there. Again, the staff has been working very hard. People remember that a year ago, with the introduction of the PTL, with the increase in the numbers of complaints with the number of application for licenses up upwards of 70%, there was a backlog that had developed. That backlog has now been dealt with, and the initial review process is back to where it was before the initial surge. A careful reading of the numbers in terms of applications received, initial reviews, and licenses issued indicate that we are maintaining, keeping pace with the number of applications in. So the backlog is not increasing. And so we are in a good place, but we know that there will be an increase in the number of applications, and we will continue to carefully monitor the situation. But just it's important to note that the licensing staff in difficult times has managed to right the ship, and we're issuing licenses at an acceptable rate. Going through the rest of the licensing update, it's been well known that the Federation of State Medical Boards and the National Board of Medical Examiners have announced the discontinuation of work to relaunch a modified Step 2 clinical skills examination, the USMLE Step 2. There have been a number of waivers which have been granted in terms of extending the deadline for the postgraduate training license. We continue to do a lot of work in terms of the rollout of the Docs portal, as was mentioned earlier. This is a very important initiative and continues to be used by more and more stakeholders. And the Consumer Information Unit remains extremely active during that time. Myself and the rest of the executive would be happy to answer any questions.
Mr. Pacifica, thank you. Do any board members have questions?
Yeah, Madam Chair, Mr. Pacifica. So I have a couple questions. One is that I'm looking at 6A, page 17 and 18. Is that the amount we can recoup if we get the recoupment of monitoring, probation monitoring costs and all that? I'm just curious. I was always trying to see what is the amount we can recoup from the people we discipline if we if we go through the legislature to get that approved.
Okay, we're looking at that.
It's page 6A.
Yeah, no, sorry, we've got that.
Yeah, doctor, I think you were referring to cost recovery. No, this is not the cost recovery. This is the actual money that was collected through the probation monitoring.
Okay. So, but do we know what the actual money we can collect it will be if we go for the recovery?
We don't know. We are going through that process of estimating that right now, but we don't have that number for you today.
Okay, can we have it for the next board meeting, please?
Well, okay, yes, of course, we will continue to work on that. But again, we're talking about projections here.
Yes.
We're talking about projections. And so the best predictor of the future is what's happened in the past. We're looking at various models in terms of how much we have been able to collect in the past when we had that. From my own experience, it's one thing to be awarded costs is entirely separate than to go and collect those costs. And I have always felt that cost recovery was extremely important. As far as I'm aware, we're the only DCA board that does not have cost recovery, but that the real benefit from us in cost recovery is not simply the amount of money that we recover in hand, but the effect that it's going to have on future litigation activities, which is something which is difficult to quantify because it really amounts to savings in terms of litigation costs that we would never incur. But we will do our best to come up with what we think is the most robust model and then to report on that at the next board meeting.
Yeah, I mean, in the end, any budget in any company is projections. So that's what we want. Because we want to see where we are including cost savings and on your future litigation, because that is an important part. So that way we get an idea, because we approved, the legislature has to approve one of the highest license fee in the country, by the way. So we do have to look at the other areas where we can save. Our expenses are very high, whether it is the AG's office or HQIU. So we got to look at also savings along with increase in this board approved the increase in license fee. You can't just rely on one. Thank you.
Dr. Hawkins.
Dr. Hawkins, please.
And a little bit out of order here, and I don't have a question for Bill, but he mentioned staff. I don't want to take this opportunity to really commend our staff, as well as others in the help of preparation for Sunset hearings for me. And I know the other folks that came at Sunset yesterday will say the same, but I did have meetings with governor's staff. I had meetings with DCA staff. I had meetings with Gloria Castro. I had meetings with Kathleen Nichols. These are all to help me have a better understanding of how they can help us do a better job that we're entrusted and have to do. With regard to medical board staff, Bill Francisca, Reggie Bargis, Carrie Webb, Charlene Smith of CCU, and extraordinary above and beyond work from Aaron Bone. Thank you all very much.
Yeah, I would simply like to echo that. It's been a very rewarding time for the staff. I know they may chuckle when I say that, but they've risen to the occasion. But I hope the board member will realize there'll be a couple of us, maybe on Monday in the office, you're not going to see us.
I have
Any other
question.
I'm sorry, I didn't see who that was.
Tita.
Oh, Mr. Watkins, please proceed.
Hi, Bill. My question has to do with enforcement because it's something that I'm looking at real closely, and I'm concerned as usual about this is showing operational efficiency. And when you talk about being effective and being efficient, then I've got a simple question to ask to show the effectiveness, right? And you were talking about the appropriateness of resolving smaller cases. Do you have any idea how many letters of public reprimand you've written from the beginning of this year till about the end of April? And what has the average been?
Well, of course, we can give you all that information.
Well,
no problem.
Well, what I was referring to is that you don't have that right now, and that is actually an enforcement statistic that pertains to the qualitative nature of the decisions that we make. And I'll give you that number. I mean, I can tell you that right now for this year, from the first of this year till the middle of April, we've done 64 public reprimands as per our public records that we publish on the website. And that the average for this period for the last 10 years has been 31. So what I'm concerned is in alignment with what the patient advocates are saying, is that when we hear that you are going to become efficient and effective, does that mean that we will now use a tool as a catch-all? And public reprimand becomes a catch-all tool. And what we throw in that catch-all little basket of us is all kinds of cases that is complex, that has consumer issues in it. You see, my question at the last board meeting also was related to asking questions about the enforcement outcomes, not the process. The process is one thing, and that's all good. You've got that down. But the outcomes, because the outcomes is actually the only thing that the public cares about, ultimately, because that affects what happens to these cases. And so that's my concern, that we don't have, again, like real public protection data. We have efficiency data, absolutely. But we're not demonstrating how effective we are in actually adjudicating these cases. So that's my only comment. Thank you.
Okay, if I could just address that on a number of different issues. Well, first of all, it's in terms of the enforcement data and information that we present, I am happy to report that information in whichever form you like. And if we want to have an additional report about the numbers of reprimands, of revocations, of different kinds, I'll be happy to do that. I mean, that's information which we have. And it's very important that, I mean, the executive exists to inform the board, and we'll be happy to do that. Secondly, the indication that we're issuing more public letters of reprimand, I can assure you this does not mean that we are using it in circumstances where we should be using much more stronger disciplinary tools. They could be in many cases where there would have been no enforcement before. I can assure you that in all cases where we believe a revocation is appropriate, that we are pushing those cases towards revocation. Meeting with the staff, even this week, there were a number of cases which we were discussing in conjunction with the Attorney General's office, which we were pushing to go for revocation. Every single disciplinary tool has its appropriate place. Similarly, every single disciplinary tool may be inadequate in nature of the offense for which we are confronted. For example, there may be, one would hope, a very small number of cases where revocation itself is inadequate. For example, in cases where there is a serious criminal offense and there should be a criminal sanction. So that's always going to be the case. In terms of the public letter of reprimand, you're absolutely right. There may be certain cases where it is inadequate. On the other hand, there may be certain cases which issuing a public letter of reprimand would be an abuse of our prosecutorial discretion if it is not significant enough, where it is not a matter of addressing public harm and requiring a public letter of reprimand. So it goes simply without saying that it is the job of the executive, working with the Attorney General's office, to look at all of these cases on their merits, to develop robust methodologies, to work within the parameters of our existing legal system to drive each one to have the appropriate level of sanction. If I can just give you a couple of examples to illustrate some of the challenges that we face. There was one case, I don't want to get into any details of it, but the investigation went on for page after page after page, and 10, 20 different patients had been interviewed, where to me it was quite clear that what should have happened at a very early stage in the process is that we had enough information to go in for an ISO immediately, thereby protecting the public. So there are all sorts of eventualities that we have to look at. Sometimes you have to cut investigation short, go for an ISO. Other times you reach cases where the investigation is not thorough enough to uncover what we think is the really serious point. It's simply the fact that there is no one metric that captures all of that. I am pleased that we are able to close more files than we receive. But that's not the end of it. Absolutely, that is not the end of it. What we need to do is to deal with each case appropriately, and there are many kinds of cases where I can assure you where we are pushing for revocations in cases which have not been pushed that way before. And finally, can I add that the executive considers the input from the board and the board members to be absolutely invaluable. The outturns of the panel is extremely important information for us in terms of how we do our job. It is very important to have robust discussions on these cases. And finally, if I can just note, I watched with extreme interest the confirmation hearings of 4 of our members this week, of 3 new members, and we take their comments and their desire for more interaction with complainants, for greater transparency, extremely seriously. The executive has no agenda other than to follow the direction of the board and to protect the public.
Mr. Prescott, Ryan Brooks. First, I want to say, thank you for all your hard work you do, the work that the team does. I think there's two parts. There's one part about getting the statistics, the numbers, like the numbers of reprimands, which is great. It's how you use that data that really, makes sense. So my question is, are we seeing trends? If you're issuing more letters of reprimand, is there a trend going on? And the reason I ask the question is sometimes we see trends for various reasons. We could address those before it happens to prevent the number of letters that go out or the number of stipulations that go out.
I can answer that very clearly. The trend that has been up to now for this period that I'm saying first of the year to about the tax date, the average for that has been 31 reprimands for the last, since 2008. Well, so let's say for the last decade. And in the last period, just for 2021, it rose to 64. So it broke the trend. So on a graph, it would look like this, and then suddenly it spikes. So my question was that since it spiked, I just want to know whether that spike is because unconscious policy is in a policy is in place that has an undesired effect, that suddenly we're writing these public reprimands, warranted or not. It's at twice the rate since last year. And that's my concern. I'm watching enforcement data. And if there's any break in the trend, then I point it out. This is one thing that I picked up. Nothing else. Thank you.
Thank you for the question. Yeah, because I look at, statistics and numbers all the time. And the numbers on a piece of paper, they're just numbers. But if you kind of dig down to the tabs of what they actually mean, we can, that's kind of the first step of preventing, an incident from happening in the first place. If there is a trend because the doctors are being, overworked and having good record keeping, we should identify that and figure out how to solve it before it becomes a problem, which would hopefully reduce our overall enforcement, activities within the department that would help save money and cost. So that was kind of the basis of my question.
Yeah, and I'm just going to conclude with this. My concern is the board is under pressure with money. The staff is under pressure because we are under a big caseload, and suddenly, I see the spike in public reprimands. I don't want to come across a situation where these public reprimands that are issued are on some level just becoming the catch-all basket that we throw stuff in. I am trying to just be very vigilant about making sure that these are not a method that we use because we don't want to address it. And I'm not saying that is happening here. I'm just saying when there is a doubling in 1 year of a trend of public reprimands, and the average has been pretty much a flat line for 10 years, then you have to ask that question. It's just a simple vigilancy that you have to maintain. And that's it.
Thank you, Mr.
Sorry, Ms. Lawson, can I address Mr. Brooks' issue there?
Please.
One thing I think you've raised a very important point, which I think is sometimes missed, is that if you're looking at the success of a regulatory system, of course, the disciplinary outturns are very important. I'm not suggesting that they are not, but they tell a very incomplete story. What you have to look at what else is being done. If you had a jurisdiction in which you had, let's say, the highest rate of discipline that was going on, you'd have to ask some very serious questions. How robust are their licensing mechanisms? How much what about even looking at the entry levels into medical school, how people are chosen to become doctors? You have to look at CME. What changes can be made to CME so that you can prevent these problems from developing? It's the entire area of upstream regulation. If you have a very successful regulatory system, you would expect there to be fewer disciplinary actions because standards were maintained and standards were being developed. The problem with this whole area is that the problem is that if you just look at the numbers alone, the best medical boards and the worst medical boards could look very similar because they would have relatively few disciplinary actions. And that's because the worst boards are not effective at imposing discipline, which is a real problem. But the best boards in a robust regulatory system where you have developed a culture of open disclosure and continuous improvement will generate less need for discipline. So it's our job to do everything we can within the complete regulatory system to make it work better and to ensure that when those cases do come to us, each one achieves the appropriate amount of attention and the appropriate discipline. And that's how we can get there. But I agree wholeheartedly, the numbers alone do not tell that story.
Mr. Francisca, I have another question. During our confirmation in the Senate and also at the BMP hearings, we heard that how are we closing the complaint? That is, if a complainant sends a letter or calls the board, how are we keeping him in the loop and informing them? I was a little concerned that they're not getting information and they're somewhat in the dark, so that was important for me. So if you can explain, if we're making some changes, what we're doing.
Yes, as we have set out in the report, there are a number of changes that we are looking to implement. The first thing is that we're looking to develop an online tracking system with our IT experts so that complainants can look at it externally and to see where various milestones have been met. Secondly, what we have done even in the past period is to begin to audit communications we have with complainants. The goal is to keep complainants informed to the extent that we are able to under the Act. Again, the Act provides that the complaint process is a confidential process. They're not entitled to, for example, expert reports and to confidential patient records that obviously have nothing to do with them. So within those parameters, we are developing protocols and procedures. We are going to continuously monitor how that is implemented, and we have acknowledged that we have some ways to go. We have to give them more communications. It has to be more meaningful communications. But at the end of the day, we operate in certain constraints because the Act provides the complaint process is a confidential process. So we're looking to continue to monitor it, develop more grounds for communications, to set out certain milestones, have more regular communications to monitor that, and we look forward to reporting to you about that at each meeting.
Any additional questions or comments from members? Mr. Roop?
Just to finish up.
Sorry.
But in the end, though, I think if I am the patient who sent a complaint about the doctor, I want to know that whatever you did, I don't want to be left in the dark, and that was very concerning to me when the people complained that they were in the dark. So please let us know by next meeting what are the changes and how we are doing.
That's fine, absolutely.
Mr. Rue, I saw your hand up.
Thank you, Madam Chair. Very interesting discussion. I wanted to follow up, piggyback on Mr. Brooks's question about trends. You know, on 6B, page 10, where you have the average HQIU investigation days by case type, it seems like the days all fluctuate, but for the unlicensed activity, there's been a consistent trend ever since 2016. Can you kind of comment on that?
Well, I guess for board members, who have been looking at these numbers for a long time, we have seen the time frame for investigations to be going continually upward for many areas of investigations. And one thing which we have been able to do, and which we have just completed, is to put in place a new memorandum of understanding between ourselves and HQIU, which provides for much more constructive and active engagement between the executive and the HQIU. It's not simply a matter that the file goes out for investigation and then it comes back to us a year later, 18 months later. We're going to track various milestones. We are particularly concerned about the aging of cases. And we have a very important reason for that. We deal with the 3-year statute of limitations within which we have to file an accusation. And in too many cases, we've been running up to that 3-year limit. And once that limit is passed, we have to then go with whatever we have. That's why aging is particularly important. So what we are going to be doing is using the MOU to more actively monitor these cases, and particularly the ones where there's the most aging are the ones that we have to be concerned about. But that is a source of concern for us.
So there's no, because I've noticed all the categories go up and down and fluctuate, but the unlicensed activity has been a upward trend steadily, and it's not just this year. It's just for the last 6 years. Yeah. So I was wondering, is there something in particular about unlicensed activity, or it just happens to be?
Okay. Well, no. I'll tell you what. We will have to get back to you on that. Okay. I promise we'll get back to you on that.
Mr. Pasifka, just to follow up on Mr. Rue's question too, because I think, this is an area that has been of great interest to us, meaning the board and then meaning the board leadership as we prepared for the Sunset Review hearings and prepared for the conversations we had with the committees in the legislature. And one thing, as we prepared for some of those hearings that became clear to me behind the scenes is that when we look at averages, there's data in those averages that is really skewing a number. So for example, if there's a case where a district attorney in a particular jurisdiction has reached an agreement with the AG's office that we will not pursue an enforcement case while that criminal investigation and prosecution is underway, that can greatly lengthen our cases, but that doesn't show up in this data in a way that is helpful for the board members to understand, for example. And I wonder if we can just figure out, and I know that staff is working on a table that actually includes some of that information so when something gets put on hold, it doesn't continue to, for example, count against that average number, right? And really skew it so that it looks like there's a trend occurring that may or may not be. I don't know if that's the case in that unlicensed activity category that Mr. Rue was just asking about, but I remember that coming up in our conversations about these averages and how we present this data. So I would just continue. I mean, data is great, right?
Yeah.
So long as it's providing you with meaningful information that is then actionable in a meaningful way. And so to the extent we can continue to improve these data streams we're receiving so we know what's really going on, so that when there's a question about, well, why aren't you immediately jumping on that doctor with an enforcement process, perhaps there is that reason. Perhaps it's because there's multiple agencies involved, what have you. But so that's my comment. Are there any other comments or questions from board members about the executive management report?
I just want to comment on your last comment, Christina. When you have outliers, you can pull it out of the data set and keep it and say this is the outliers if you want to maintain the integrity of the trend set on the data. This is all just little things that can be noted on a presentation like that on a graph. And so the deal is, if you want to make data consistent, then you can set a standard where you say, okay, I'm going to remove the outlines and explain it in a note. That's just to help with this process.
Yeah, I agree with you completely.
Yes, Ms.
Additional
Lawson.
Dr. Thorpe?
Well, Bill, I think that number one, we do have such, we really do appreciate all the work that you and Reggie and the staff are doing in all these areas. But it is one of those things where, repeatedly the delays in getting activity completed on a case is constantly brought up by our, by the legislature and by our friends in the public sector as well, and our patient advocate sectors. And I would just point out under item 6B on page 8, the days to complete investigations in the complaint investigations office, for some reason, it was actually looking pretty good in 1920, and now in 2021, quarter 1, quarter 2, quarter 3, it's progressively increased. So we were at less than 6 months in closing cases in 1920. Now we're back almost, we're approaching a year now. And so it's not that I want to necessarily hound you about that particular statistic, but it's just those kind of things that continue to concern us about making sure that we are working, that I think what TJ was saying earlier, that we just want to make sure that the letters of reprimand, okay, maybe we are seeing more, but let's at least make sure that they're appropriate and that we're not just giving letters of reprimand just to get them off the books,
Yeah, well, okay, on that point, I can assure you there. And also, I've just been given a chart with numbers about the letters of reprimand, and I will be asking someone to add these up for us, and I'll be able to have those distributed very shortly. In relation to the particular chart that you just mentioned, average days to complete investigations in Complaint Investigations Office, that's 6B8. First of all, Dr. Thorpe, I do not consider this hounding. I consider this to be a very important part of your role. Number two, the hounding is not limited to you. It's also, I am involved in a certain hounding of staff, and I asked them specifically to look into that. And what I was told, as with everything, there are a number of factors that account for the increased timeline in this area. First of all, we've had an employee who had to be reassigned to engage in tracing in terms of our obligations under DCA. Many of these pending cases date from 2018 and 2019 and involved subpoena enforcement actions, which necessarily have resulted in greater delays. Also, I think thirdly, what we're finding is that, frankly, we're taking on internally some more difficult cases than we had done before. And so this attributes partially to the reason for the increased timeframes. It is our goal to get the timelines down, doing everything reasonable while still maintaining the integrity of the public enforcement function and still devoting resources. And there will be cases, frankly, which require more time and more resources for public protection. And so we are doing that, but we will be focused on this area. We've identified some reasons for it, and we hope to see some improvement by the next board meeting.
Dr. Yep.
Please, Dr. Yep.
Yeah, one last comment about the PLR. I actually had a conversation with Jones way back last year when we were expert training on Melinda. I think it's a good idea for Bill and Jenna to have a report on the number of PLR that was vetted by the executive alone and those that go to the board, and also the severity or the background of those cases and the criteria that would help the board members to understand, why the number increased. Is it because we try to save costs, or actually because we're more efficient? And also, what are the criteria that the staff can use to give out PLR with the board approval? Thank you. I think Jenna has those numbers.
Yes. Okay, yes, we can do that.
Thank you, Dr. Yep. Ms. Campoverde.
Yes, while we're on the topic of useful data sets for our oversight process, I know Mr. Prasivka and I have already talked about this, but to speak about it with the full board about regular reporting on the criteria we use to close cases, including staff interactions and how and why those cases are closed.
Thank you. Additional comments, questions from the board members? Ms. Lubiano?
Yes, thank you. Just to dig into a little bit more from Dr. Dev's comment about the system that we're putting into place to inform complainants of the status of their case. I know it's top of mind for complainants as well as us board members, and also the legislature, which did ask about it, as you may saw in yesterday's hearing. And so my understanding, just for clarity, is that we're working on it. I hear that we're talking to our our tech experts to see what existing technologies perhaps we can leverage. So I just want to, one, I'd like to understand if we have a tighter timeline as to when that might be in place. And then also, I'd like to understand how we're thinking about it in terms of, I see, okay, we're trying to perhaps leverage what we have, but if not, is a backup, to build a new one or, get a third party that can build one for us. And I understand, obviously, that costs money. So just wanted some answers there, please.
Well, first of all, I can assure you that this is a matter that has the highest priority. When I report in terms of the outturn from the public interest meeting, I was prepared to speak about it there. But just to say what we are attempting to do is to roll something out as quickly as possible to identify a number of milestones for which we can build into the existing system so that in a relatively user-friendly way, complainants can access where their complaint is at various parts of the process. Obviously, we need to do a legal review to ensure that the information that we are disseminating is consistent with the confidentiality provisions of the Act, and also that we're able to do it within a technical point of view. At this point, the priority is to develop whatever we can as quickly as possible and to roll it out as quickly as possible. If that is deemed to be inadequate and doesn't meet the needs or expectations, well, then at that point, we may need a more comprehensive or radical solution. So that's where we are right now.
Well, can I speak, Madam President?
I'm sorry, I didn't hear. There were two. Dr. Mahmood?
Yeah. So this concern about the timely investigation and conclusion has been, I've been on the board for 2 years, and even before that, I've been listening. And every meeting, every time, what we say is, we are going to try to improve, we're going to try to get better. Is there a possible way that we can set some standards? Okay, next 6 months, we're going to bring it down to this level. And then in a year, we're going to bring it to this level so that we follow those protocols or whatever the standard we set up, number one. Number two, there must be some cases which are very complicated and intrigued and they need a lot of, we put those cases aside and put an explanation on those cases. Okay, this is the reason these cases are taking so long. Let's not put them into the all standard cases and have like duration of investigation so long, so that we see average like 98% of the cases are timely investigated, timely prosecuted, timely whatever the conclusion come, and we put all the progress on the website, and especially board members are given the timely information, like every month or every 2 months or every meeting. Okay, this case is long, that is why it's taking so long. Because when somebody come in and say, okay, this case has been going on for 3 years, we are speechless. And honestly, we should be speechless because public has concerns. Public really want, and we are working here for public. And we really want to answer them and just give them an answer. Okay, it's a complicated case. We need to know all the details, why it's taking so long, and where is the problem. Maybe we can intervene and we can cut down that time so that it doesn't affect everybody. And we should have, on a timely manner, cut down our target, where we should stand and what should be the time limit.
Okay, well, first of all, I completely agree with the need to give adequate reporting data. if I could refer you to, again, the last data in the enforcement package, item 6B13, the pending enforcement caseload summary, that tells me two important metrics. One, what are the total number of cases in the system as to how they compared before? And it also gives you the case aging, which is very important. Now, what we need to do, and this was always the intention, is that as we had more data coming in this format, then we can do a more effective trend analysis. And so we would hope that in future reports, now that we'll have a fourth one coming out, so we have 3 sets of trends, we can draw some conclusions over the aging of these cases and where they are at various portions of the project. That's one way that we can deal with this. We are always looking for newer and better ways of communicating the information to the board and to the public. And certainly we have also, I mean, the reason you have this data is that you can identify the cases, identify the outliers, and devote additional resources to dealing with those. So that's what we're doing. We'll see how that looks, if that addresses concerns, and this is something in which we can report at every board meeting.
Can I just ask a quick question, Bill? You and the staff are building out a model that's effective and efficient, right? And that's going to include these timelines and everything. So before we build this, redesign a system, we do an audit of the system, and we establish, hey, what are the kinks in the system? Where does the system break down? If you could give us just a 3-point maybe, or maybe even more extensive, and give us an idea about what those things are. What have you found, and what is the solutions that we could expect? Because if you say effective and efficient, we become concerned, or I'm concerned. I'm going to speak for myself. So if you explain to me, you bring me on board and tell me kind of what your process will look like.
Okay, well, I guess I'm sorry for using the words effective, efficient. I studied economics when I was in university, and I guess I contaminated myself. But no, all kidding aside, no, it's our job, absolutely, to explain these things as simply as we possibly can. But I can assure you that the executive is not lost in the numbers. Maybe what we as the executive need to do is to better explain how in so many different ways we are pushing and a public enforcement agenda. All the numbers of cases in which we are working very strongly with the Attorney General's office, who is a very effective and dedicated partner to achieve stronger disciplinary outcomes. I mean, one area we're working very hard with is in the area of financial fraud, which I have spoken about. We're not talking about technical violations here. We're talking about physicians who, unfortunately, have defrauded the public health system of tens of thousands, hundreds of thousands, and in some cases, millions of dollars. These are very serious matters, and to me, it's not consistent with the practice of medicine. And we need to treat these things with the highest degree of seriousness and with the most serious sanctions. And we're seeing that we are making progress here, as is the case with other areas. And that's all part of the process.
Additional comments or questions from board members? All right, seeing none, I'm going to ask the host to please call for public comments on the executive management reports.
The Q&A window is open, and anyone who would like to raise their hand can make a public comment as well. First up I see here is Sandra Perez. Sandra, are you there?
Yes, I am.
Please go ahead.
Statement made by Ms. Lawson about the outliers in the licensed, unlicensed category, that you talked about some of these maybe cases that you guys can't do anything with because there's a parallel criminal investigation. I beg to differ. In our case, when we submitted a complaint with potential felony ramifications, The board dismissed it in less than 30 days. Second to that, I would like to say that as you guys look and move towards enforcement and putting information online, one, it has to be meaningful information to the public. It can't just be information that has no bearing on what the public is asking for. Second, to Dr. Mahmood's point, it has to have measurable steps to it. You guys can't sit here and repeatedly say that you're going to take action, and here we are months later, and still no action has been taken. Measurements have to be put in place for you guys to be showing progress. And that's one of the issues that is also not happening. Thank you.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you. I would just like to comment briefly about the expert reviewer program and concerns that I have about that program in the context specifically of my main topic, which is the need to restore access to special care for intractable pain patients. And we're talking about those patients who have severe, constant, life-altering intractable pain. That pain does really exist, but because of a number of factors happening in our country, I think there are fewer and fewer doctors practicing who understand how to treat these patients. And it would make sense to me that there are not too many, perhaps, of your pain care, pain medicine related expert reviewers that fully understand the kinds of care necessary to provide effective medical management of these patients. And we have many, many patients who have lost effective care that helped them for years or decades. So I would simply say in regard to that program, if there is a way to specifically seek out doctors, I'm not saying that your reviewers may not be perfectly well qualified to review pain care for the more common chronic pain ailments. But I find it rather unlikely that you have reviewers who, very many of them, would be expert in fair and understanding what they might be looking at in terms of a doctor trying to treat intractable pain that turns into a syndrome with measurable cardiovascular and endocrine dysfunction and leads to premature death. It's a whole different ballgame, and I would like to suggest to you that you try to find a way to be more selective, perhaps, in choosing folks to participate as expert reviewers for intractable pain, and perhaps echoing an earlier comment about the need for training on intractable pain, that it would be beneficial to board members, but also especially to expert reviewers if they're not quite up to date on that, and to the investigators who are looking into the doctors about whom you may have a concern. I think that we have lost way too many doctors who have the expertise to effectively treat people with the intractable pain type syndrome, such as my husband and a number of other patients I represent in my group. And that's an area that has led me to have great concerns. I have observed just in reading, I will not mention any specific cases. I don't know the details of cases, but there have been certain cases where there was an appearance that doctors who were being challenged or questioned may have simply been providing what they know to be the kind of life-saving care that patients like this really require. Thank you.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
All right, thank you. Good afternoon. My name is Marion Hollingsworth. I don't know if Mr. Pacifica can answer questions, but I was wondering about the average and median length of time for the processing of a complaint, which has been increasing over the past 5 years. I know you just addressed this somewhat, but this has been an ongoing issue. On page 6B, page 12, you have a median time of 1,209 days and an average time frame of 1,128 days. This is more than 3 years. Other states have limits for the number of days the board can investigate a case. Washington, for example, there is a 5.5-month time period, or about 180 days. How can California's time frame be lowered without having to get the legislature to impose a law? This long time frame is discouraging to consumers who have filed a complaint, and it keeps potentially dangerous doctors in practice while you determine if there should be a discipline. Also, regarding enforcement and following up on Mr. Watkins' comment on public reprimands, There has been an increase in the use of public reprimands for egregious cases such as preventable deaths. This includes childbirth deaths and overdoses. There are at least 3 such decisions recently where a baby died in childbirth years ago, and the doctor just got a reprimand. This includes a 2013 case where a young mother bled to death after a C-section and a VBAC death where the doctor failed to monitor the baby and inform the emergency surgical staff. The Death Certificate Project also had a number of reprimands. You had one overdose death case that took 4 years and 4 months to resolve. This was the Alex Smith case. By giving a reprimand, there is no summary on the doctor's profile on Breeze to warn patients of a potentially dangerous doctor. And the doctor learns that even a preventable death is not a serious offense. If a doctor is found responsible for a preventable death, there should be more accountability. It's like a bank robber shooting a guard and being allowed to plead down to running a red light on his way out of town. Using reprimands in death cases should not be the norm. Right now, it is common, or at least not uncommon. How is this in the interest of public safety? Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. Good afternoon, board members. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Yes, reaching out to the families is critical, and therefore, you need to send letters to the families letting them know an update on their complaints. Currently, the families are not receiving letters. I have families that may get an initial letter, but that is it. They are not receiving a letter when the case is under investigation. They are not receiving a letter if an accusation is filed in relation to their complaint. They are literally hearing the accusation news from members of the public who are checking the physician profile and or are signed up for email updates. It is not acceptable that grieving families do not get notified first and have to hear from random members of the public or from me about their complaint. This internal communications audit team needs to expand beyond the central complaint unit and needs to include all areas of enforcement now. Families should have the right to hear that their complaint has reached a critical milestone directly from the board. Thank you.
Thank you for your public comment. Next up, we have Eric Andrews. Eric, are you there? Please go ahead. Thank you for your public comment. Next up, we have Marissa Vismara. Marissa, Marissa, are you there?
You got it. Thank you. Yes, I'm Marissa Vismara, Senior Policy Coordinator with the California Primary Care Association. First, I want to start off, thank you to the board for the opportunity to give public comment on a very important issue. the postgraduate training license. The 2020 transition to this restricted license and affiliated requirements has created significant detrimental impacts to California physicians' training and residency programs, access to care for patients, especially those in communities of color and hard-to-reach areas during the pandemic, and future healthcare workforce as the state has a growing provider shortage. We value the board's engagement during the last 2 years. We've met in July and December of 2020, and January, March, and May of 2021 to discuss our concerns with the PTL. One of the most significant issues, as referenced in our coalition letter, is that PTL holders are unable to enroll and bill Medi-Cal for moonlighting services. Federal regulations do not allow providers with current limitations from enrolling in Medi-Cal, and 36 months training requirement of the PTL is a restriction. Medicare provisions have similar stipulations on license restrictions for providers. In these conversations, we've learned that the origin of the PTL, the board, and unfortunately prior to the PTL, there were residents or bad actors who didn't complete their training program, but went on to practice medicine with their unrestricted license. When we asked to see the data of the board was unable to provide it. I appreciate the board's comments during this meeting on the value of data, and I encourage additional data to be produced for us stakeholders to better understand the origin of the PTL, and as Ms. Lawson mentioned, make meaningful action. In the past 2 years, we've been in ongoing discussions with the board and state health agencies and are no closer to a resolution or concrete changes. Our ask of the board and its mission to promote access to quality medical care through the board's licensing and regulatory functions is to either eliminate the PTL and return to provisions and licensing statutes and requirements, or propose legislative language that will resolve the listed challenges. Thank you so much, and we look forward to further collaboration.
Thank you for your comment. Next up, we have Virginia Farr. Virginia, are you there? Virginia, I've opened your microphone. Are you there?
Hello? I'm not sure if I have an echo because I'm on my computer. Does it sound okay?
Sounds okay, yes. We can hear you fine. Please go ahead.
Okay, my question is, this computer database you're building, will it have where patients can enter the type of error and you can hold down on the type of error and then prevent that type of error? Like an example, if 50 patients had an NG tube placed in the lung and nobody did the x-ray, are you able to know that specific error is happening and prevent it from happening? Also, it'd be very helpful to have a member of the board, this patient safety expert, so they can help prevent the errors from happening in the first place. Either that or hire a consultant in patient safety, because we need to prevent the errors from happening to be effective and efficient and not have all 10,000 cases because we didn't prevent them in the first place. And that's it. Thank you.
Thank you for your public comment. Next up, we have Rosie Arthurstatter. Rosie, are you there?
Yes, I am. And I had to step away again to take care of some critical things. And then my computer decided to take and do an update. So I'm not sure where I am in this process, but I think I'm responding to enforcement activity. Is that correct? Or have we moved on?
We're on the executive management report from Mr. Pasifka.
Okay. All right. On Part B, going back again to the right to know of 2018, there is the way that is written, it leaves everybody who's either unconscious or in a emergency room, urgent care, or has a bait and switch, a floater comes in, they don't have to inform people that they have a cease order practice against them. It seems to only help the patients, existing patients of a particular provider. And so that's a problem. On the site, as I said before, when you go to the alerts and click on the cease practice order, it goes to a 404 error. When you go to the profile, it doesn't show up at all. There was a site called forpatientsafety.org that actually had archived some of the older stuff that is not there any longer. So one cease practice order was published at one point and has now been removed. So something is going on with how that is being displayed to the public. So that's one thing I need to bring to your attention, and also to commend this group for patientsafety.org, because they did a wonderful job of archiving this information and presenting it in a clear, straightforward, unbiased manner. So that was good. Then the other part is under the expert reviewer program. In the examples of the materials for the expert reviewer program that are available online, it does make reference to the laws regarding intractable pain. So that would be the Pain Patients Bill of Rights, the BMPs regarding it, including 2220.05. Now, apparently it's there for the experts, but then when somebody writes up the
30 seconds
complaint,
remaining.
Apparently it's being eliminated and they only go down to point 1 and stop, and they don't do point 3, which says in no case if there's intractable pain shall you use it. So when the AG person comes up, maybe we can discuss what's happening with that, why the people writing the complaints are not following the law. Maybe they didn't realize that it's 1, 2, and 3, and 3 has specific qualifications for intractable pain.
Please conclude.
Anyway, thank you.
Thank you for your public comment. And at this time, Ms. Lawson, I do not see any additional requests.
Thank you, Sean. Are there any additional comments or questions from the board members before we move on to the next item? Right, seeing none, we will move on to the next item, which is item 7, update from the Attorney General's office. Is Ms. Castro with us?
Yes, can you hear me?
I sure can. Welcome.
Welcome. Thank you very much. As you know, our former Attorney General, Javier Becerra, has joined the Biden administration as the 25th United States Secretary of Health and Human Services. We will miss him and are very proud to have served him. Our new Attorney General, Rob Bonta, was sworn in on April 23rd, 2021. He is a champion of all that Health Quality Enforcement Section holds dear. We're very proud to serve him in executing his vision for the Department of Justice and his important mission as California's 34th Attorney General. And then finally, in my report, Supervising Deputy Attorney General E.A. Terry Jones III is retiring from state service after having been a public servant for 29 years, the bulk of which was in the Health Quality Enforcement Section, which he joined in 1992. Under his guidance, dozens of deputies have achieved great things for all of our clients. The Attorney General's office and the Health Quality Enforcement Section will truly miss his professionalism, dedication, and expertise. And that concludes my remarks. Thank you.
Thank you, Ms. Castro. Are there any questions or comments from board members? And I guess I'll start with just please pass along my congratulations on his retirement.
Thank you very much.
Questions or comments? All right, seeing none from the board members, we'll ask the host to call for public comments.
Okay, once again, the Q&A window and the raise hand feature are activated. If you'd like to make a public comment, please do one of those two options. First up, we have Rosie Arthur's-daughter. Rosie?
Hi, okay. Continuing on with section 2220.05 of the Business and Professionals Code. What I have noticed in the accusations and the other enforcement documents from the death certificate project and in other cases, what we have is a number of cases involving intractable pain for which Part 3 applies, not Part 1. But apparently when the accusations are being written, they're stopping at 1 and using that to do rather severe disciplinary actions when it might otherwise be a reprimand or, something covered in correspondence, paperwork error or whatever. But any of those then are classified as number 1. And then instead of going down to number 2, where it says Let me get it right at number 3. It says, however, in no event shall a physician and surgeon prescribing, furnishing, or administering controlled substances for intractable pain consistent with lawful prescribing, including yada, 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 of the Health and Safety Code, 124.960 and 61, says, be prosecuted for excessive prescribing, and prompt review of applicability of these provisions shall be made in any complaint that may implicate these provisions. And so what happens is you have a number of them, it's hard to say how many, but too many for me to count, where this applies, and there's no mention of this provision whatsoever. Every time a license is revoked, the person is induced into surrendering it, changing their practice, dismissing or tapering their clients. It means that for every one of those practitioners, 250, 500, maybe 1,000 patients are adversely affected because when they can't get their medication appropriately prescribed, no other provider is going to take them because they don't have to. Nothing requires any provider to take one of these patients.
30 seconds remaining.
As a result of these types of tactics based on, some cases, on paperwork errors, people die because they can't get their pain relief. They suffer needless pain and psychological pain, physical pain, suffering, financial pain, and all their caretakers and families, the people they interact with, their community, all suffer when somebody forgets to go down and look at this applicable thing. So I'm hoping that the people in the AG's office will look at what they're doing when they're writing these complaints, because each one of these could be challenged. And it's caused thousands of deaths, no doubt, by now. Thank you.
Thank you for your public comment. Ms. Lawson, this time I do not see any additional requests.
Thank you, Sean. Are there any questions or comments from board members for Ms. Castro?
Ms. Lawson, this is Dr. Thorpe again. I don't want
Dr.
to
Thorpe?
prolong the discussion, but I would just point out again that, our budgetary allocation for the Attorney General's office, we are going to be over budget by approximately $4 million if we continue on the current course. And it is troubling that we are seeing no change in, or no decrease in timeframes for adjudication of cases, even though the board is paying more money for those results. And it's, the idea that we can just go to the legislature and ask for a bigger budget is not really a viable option. So I would just point that out, that we're still in difficult straits financially, or will be soon. Currently, we're not, because we're not through the year, but we're only 5 months into the year.
And Dr. Thorpe, I would just observe, and then I'll ask Ms. Castro if she has any comments, but I agree with you. But many of those items that are in this budget line item are outside even the control of the Attorney General's office. And frankly, to speak to some of the issues we might talk about in our next agenda item on the sunset review hearing, items like cost recovery, for example, where there's currently a disincentive, right, to resolve cases earlier on in the process, and there's every incentive for people to use the judicial process, which the AG's office is tasked with participating in on our behalf, but to use as much process as they can there to, delay and we heard earlier before when Mr. Pacifica was talking about subpoena enforcement, right? You can drag out a case for many, many years and cause a lot of attorney's fees to be incurred by the medical board with some of those tactics that perhaps if cost recovery was still a tool in our portfolio, we might not see as much of that. So, Ms. Castro, do you have any additional comments?
No, not really, Ms. Lawson. I agree with everything you just said. Mr. Chris Ryan, our budget director, is always pleased to come and address the board on those types of specific questions, Dr. Thorpe. He last appeared before your body in January of 2019, I believe, right before the pandemic, to speak specifically on the fee study. And at that time, it kind of dovetailed with the increase in the Attorney General's fees. He could speak to that much more specifically than I can. However, I can tell you that just in a quick analysis of the number of hours that we are devoting to your work, that has stayed constant. The volume of work that has come in has increased slightly, and the Office of Administrative Hearings never stopped working or hearing your cases. And so there has been no downturn in work for this DCA client whatsoever. And that's not to say that other DCA clients have not had a downturn in work due to the pandemic, but doctors continued to work, and so did we. So hopefully, if you wanted to agendize that, Ms. Lawson, our office is always available to come in and speak more to the points, and they would answer anything that you have much more accurately and fully.
Thank you. Any other questions or comments from board members? All right, seeing none, I'm going to move on to the next agenda item. Ms. Castro, thank you for joining us. The next agenda item is agenda item 8, update on the Sunset Review hearing process. Mr. Prasifka.
Yes, thank you, Madam President. Well, it's been a very busy time in terms of sunsets since the last board meeting. On March 19th, the board's first sunset hearing was held, and the focus was on enforcement. As a result of that hearing, we answered a number of questions and related to enforcement, and we supplemented our answers in the hearings with written responses to the Senate and Assembly Joint Committee. And we also gave them responses in terms of the issues which they raised in the background paper, and all those documentations are included in agenda item 8. There was a second hearing on the 5th of May, and that focused on licensing and administrative matters, and including the board's fund conditions. One issue of particular significance which was raised there was the issue with the postgraduate training license. As board members would be aware, there have been a number of different technical difficulties that have arisen in terms of the implementation of the PTL, which was first brought out in January of 2020. Effectively, there are a number of technical problems which arise out of a very simple situation. For many activities of doctors, it requires, under legislation and regulations, that the doctors are those who hold a physician and surgeon's license, full stop. These legislation and regulations were written before the introduction of the PTL. So it doesn't provide that the PTL holder can do all of these things. Effectively, what we have been doing is, and we continue to do, is to work with a variety of stakeholders, including the legislature or including the Assembly and the Senate staff members, with many public bodies who've given interpretations of how the PTL should be considered, particularly in contrast to the physician and surgeon's license. And we are doing everything we possibly can under the direction of the president and vice president and other board members to try to resolve these matters. And we've been able to resolve some, but others appear to be more intractable. We're looking to see to what extent we can bridge the gap between what the expectations are of third parties and our own interpretation by engagement with them, by further explanation. We're looking to see where possible we can change our own regulations so that PTO holders can have all the rights and privileges of physician and surgeon's licensees. But then at the end of the day, it may be the case that what is required is changes to legislation. We are working with all stakeholders, as I said, including the Senate and the Assembly. Particularly working with the Senate and Assembly, there's a lot of goodwill there to make the PTL work. We understand that there are problems in terms of aligning policies relation to family leave, in terms of being paid Medi-Cal for moonlighting, getting X waivers for the dispensation of controlled substances. We're actively working with all bodies there. We will keep you informed, and we're looking forward to further engagement. This is very much a project in the making, and we'll certainly keep you informed of it. And just to bring it to a conclusion, we have no indication that there are going to be any further sunset hearings. The next hearing may be simply a vote on Senate Bill 806, which is our sunset bill. Currently doesn't contain anything about it. And we're awaiting word on what language may be included in that bill. And obviously, we'll be working very closely with the President and Vice President on all of these issues. And I'd be happy to take any questions you would have.
Thank you, Mr. Bruce. Yeah, I was going to invite Dr. Kraus if you had any, anything to add because you were participating in these sunset review hearings, of course, as was I.
Well, I would editorialize by saying that, in my view, our staff and our executives did an incredible amount of work in a very short period of time, and I'm very proud of the work product that they produced for the sunset hearing, especially the written responses. Regarding PTL, I'm curious to know if Mr. Pacifica feels it may be helpful for the board to make a motion and establish a position that would state that the board is not looking to restrict moonlighting of those with PTL licensure. The board is not looking to extend 3-year residency training by an additional 3 months. So I don't know if those things require an expression of board sentiment, which is on the record, or if the director is comfortable in representing those concerns without a formal board action.
Well, I mean, it is a tricky question that you're asking because we're at a very much a consultative stage of the process. We have, again, taken directions from the president and vice president, and you've made it very clear to us that you're looking for solutions, that we're not looking to restrict moonlighting or family leave. The difficulty that we have is that the reason we're having these technical problems is not because of sort of the directions that the board has given us, but interpretations that have been made by third parties over whom we have no control. Now, we've been engaging with those third parties. At the last meeting, I put it to them directly that I can tell you that the board feels that the PTL holder, in terms of moonlighting, should be on the same footing as the previous physician and surgeon holder. And then I said, is that good enough for you? And if not, do we need a change of regulations? If not that, do we need a change of legislation? I have not yet received a response there. But certainly, I mean, my view is that we should press ahead with as much engagement as possible, try to resolve everything at sort of the lowest level of intervention that is required. If it's simply a matter of convincing them that there is no difference in those circumstances between the PTL holder and the prior physician and servant, so be it. If we need a regulatory change, well, then we will put through regulations. At the end of the day, if we need legislative change, I understand that the board will fully support that. So I guess the simple answer is I think it's a little premature for us to put down that statement. But I can tell you is that in those discussions, I represent that the board is looking to solve these problems.
Thanks, Bill.
I want to comment on that PTL as well, because I read all the documents as well. And, Dr. Kraus made an important point about the unintended consequences when he mentioned this. And as I'm reviewing this, it became apparent that what I was uncertain about is, are we currently working on some legislative language or other fixes to address some of these unintended consequences? Because we cannot possibly be at the consultative stage when this law went into effect in 2020, when everybody knew it was coming out. I think I feel like we're late to the game. And one of my concerns is real in light of all the other issues that happened in previous sunset, which I will discuss. This particular issue, I'm really sitting in a space where I'm asking, what problem were we trying to solve? Because that kind of got lost in this. And was this the best way for us to solve that problem? And if perhaps the way the amount of manpower and woman power and just hours it takes to come to a conclusion, was this really the intended consequence? Or was there another solution to resolve this that we may have missed? And perhaps we must have an honest conversation about that. If we did, then we can say, yes, we did make a mistake.
If I may, to Mr. Watkins' point, Ms. Webb, it might be helpful for you, and I received this feedback from stakeholders as well, that there was perhaps not an understanding of why during the last sunset review process we moved to this PTL licensing scheme as part of that, and it did. So it was adopted as part of that last process. It went into effect earlier this year, and then last year, and then the unintended consequences came as a result of these interpretations by other third-party agencies, right? But in my stakeholder meetings with some of the groups that are interested in this issue, they were asking the same question Mr. Watkins was asking about how did this come to be? Why was this considered in the first place? And to use your language, Mr. Watkins, what problem were we trying to solve at that time? Ms. Webb, I don't know if you're the right person, or Mr. Pasifka. I know you and I've had some conversations about it in the past.
I'm happy to speak to it. First of all, the board had a process for reviewing international medical schools that it limited many medical schools that other jurisdictions recognized to allow licensure in California. And so the board went to a process where it approved medical schools listed on the World Directory of Medical Schools and other resources. And the flip side of that, the board stopped reviewing the clinical rotations and removed all of the detailed processes for a school to be approved, and also stopped going over to ensure that a certain number of weeks for each topic of clinical rotations was covered. So it streamlined that part of the application process. The other side of that is that since the board was not closely monitoring and looking at that end, the more important part was that once someone started their postgraduate training program, that's where the tests would really come. So more people have opportunity to get be able to qualify for licensure in California, but they have to complete a longer period of postgraduate training to do so. The board back in 2017, when this was being discussed, well, 2016, 2017, and even before that, felt that 1 year of postgraduate training for US and Canadian school graduates and 2 years for international medical school graduates was just not sufficient for consumer protection. The 3 years of postgraduate training is the minimum that would be required to complete like a family medicine postgraduate training program, for instance. Some programs are much, much longer, but people were able to complete 1 year and then get licensed and then go out on their own and practice medicine. in an unrestricted fashion. And so the board felt that that was not consumer protection, increased the requirements, and that's what we're working through now. The interpretation about moonlighting, we think that we may be making progress on that with a different approach, but as Mr. Prasifka said, we are diligently working on this with the parties that are involved, and it may be necessary to have an interim meeting to address this more specifically, where it's agendized and more information is available.
Ms. Lawson, if I may interject, it's of interest to note that we're not the only state who's moved for more than 1 year of postgraduate requirement. And there are many other states that require 2 years at least. But these issues of moonlighting and duration of residency training don't seem to have inhibited the practice in other states. So it really may be more an issue of how other state agencies are interpreting it in California, rather than the legislation necessarily having not been drafted properly. So that's why there is the hope that these things may be fixed without more legislation.
Thank you, Ms. Webb. Thank you, Dr. Kraus. If there are additional questions or comments on any of the issues about the Sunset Review hearing?
I have a comment.
Please.
I would be remiss if I obviously didn't comment, because I showed up at the first meeting and I'd, studied our response to the Business and Professions Committee. And how do I put this? I'm kind of in this quagmire, because the data, the information that we presented is what I would call, it's really not forthcoming. And it is at a very low integrity level. And I'm using these words very lightly and very carefully, not to offend people. But we cannot have two numbers, just for the record. We cannot have two numbers for the amount of stipulated settlements we've had for a year in question, that kind of impact how we present the information. So that's the one thing. And when information is asked and you sterilize it, it becomes immediately apparent to anybody that studies numbers that number is sterilized. And I'm referring to, there was a question about how many public reprimands, and the number that was given was 80, with a note that says that some public letters of reprimand is issued prior to filing, but a number is not given. So that hides facts, right? So we're talking about transparency. So let's have a conversation about transparency, because transparency means we present the things as is and let somebody else decide. We present the information as it is so that other people can have their own interpretation of it. At the Sunset hearing, the first one that was on enforcement, everybody by now know that's on the board, that I was not part of the board's team, so to speak, because I had a differing opinion. And I think that a lot of what I have said was misinterpreted. I found things, raised my hand and said, there's some things that don't make sense. And as a previous mentor of mine says, when it don't make sense, it's nonsense. And I was referring back in the hearing to numbers that I've created. I took all the stipulated settlements and I put it into a graph. And what I did after that, I took the criteria, the most important criteria, simply, very simply, most important criteria on the disciplinary guidelines for the public protection is the probation period, right? Now, that is not the interpretation that is in this document that we presented to the legislature. because in the legislature, which wasn't mentioned in the hearing, elements of the disciplinary guidelines are met. So now we're using cool language. If anybody comes to it and they say that it starts with the minimums or whatever, or it goes 5 years or revocation, if we fall short of that, we fall short of the probationary period. We may have mitigating circumstances. What I'm not here to do today is to kind of litigate individual cases. So what I've done is, and I will distribute this to the rest of the board, I decided that to give you a real insight on what I meant and to my fellow board members, so that this can actually be an enlightening moment. And I'm really open to hearing other people's point of view. So I went for the last 13 fiscal years. All this information is available on the board site, on the annual report. And I asked public protection questions. Just public protection questions. I asked questions like, how many complaints did we have? Those numbers are all there, right? I asked, how many accusations did we file? The numbers are all there, right? And then I asked, so what was the percentage of the accusations that we filed for this period? And I came that the average for the 13-year period was that we only really filed accusations at 3.6% on average, right? And then I looked closer and I said, okay, so how many disciplinary actions did the board take in the last year and for the previous 13 years? And I discovered that last year we did 380 cases, right? And we came to a percentage of a disciplinary action rate of 3.5%. Now, why this is important? Because the numbers are really low. In fact, we are almost 1% down from the average for the 13 years, because the average that we did for the 13 years was around 4.4%. And this is important again, because now I'm breaking down the 380 cases. And that's what I spoke about at the last board meeting, that we have these 380 cases, which are the most egregious, right? They take up the most money, they take up the most time. And I asked, how many of that was public letters of reprimand? And that was 35% of that was public reprimand. Now, that's not concerning, because I have to look at what the average was for the period. It's 34%, right? So now I see that throughout the period, that was the standard, that we've been writing disciplinary and public reprimands at that rate for 13 plus years. I went further and I said, so how many times did we actually lay out probation on any of these 380 cases? And it was only 130. So let me put that in a story for you. Right now, if you ask a person that is filing a complaint against a doctor, the chances that this board will actually put probation on that doctor is around 1.2%. Now, if you think about that, 1.2% is the rate at which we hand out discipline. Now, you can go to other boards and you can find, oh, they're at 1.6 and at 1.8 or whatever, right? The point that I'm making, as someone mentioned, this is the premier board in the country and probably in the world. Why are we doing numbers like that? It is such a low rate. It begs questions of what is happening in the process. And let me just give you a number that will make you just in a very simplistic way. Let's do it in a simplistic way. We spend $60 million on enforcement. And what we get out of it is what I see on Dr. Thorpe's face every time he speaks to Ms. Castro. I see the frustration of someone that's buying something that he is not getting the value out of it. So if we want to put a value out of it. For that 380 cases to come before the board to work through the system, that comes out to about 157,574 per case for us to get to. For us to get that result, it costs us that in real money, right? Because we're sifting. The sift is accumulating costs. But here's an even crazier number. That if I say, how much did a public reprimand cost me? Out of that six, to produce a public letter of reprimand cost me $559,000 when I'm done sifting through all this information. So what does that tell me, someone with an operations background that builds systems? It tells me that there is an enforcement system that is absolutely not working. And how do we know this? Because the public screams at this end that it's not working. Everybody is saying it's not working, but we are tone deaf when it says that. So in the previous board meeting, I said, well, we protect the doctors, right? I said the board exists to protect the doctors. I'm going to rephrase that to be sensitive because it's not completely true, right? I'm saying that we have created a system that is so disproportionate towards the public that if this was a racial disproportionate, we would be issuing all kinds of legislation to change that because it's at that severe rate. This system that I'm looking at, this system as it stands right now, does not protect the public. The system as it is. And we really need to look at some of the more advanced ways in how we can achieve that. And this is not to raise issues with everybody or anybody. When you read the numbers, I can tell you a quick story, it takes 2 minutes, right? We get a doctor. It takes one of those 1.2%, right? And I put him through the system. Statistically, that will be a stipulated settlement. Statistically, that means we're not going to follow the probationary guidelines on number one element, which is probationary period. So he gets 3 years. The 3 years is what we kind of average out. But after we hand out this discipline, that doctor can come back to the board. And for the last 13 years, we will approve removing that discipline 76% of the time. So with numbers like that, it shows that we have there is nothing that makes it balance out. So what I am suggesting and what I've always suggested is let's find a place where we can find the balance. A balance in how we do this. And there's too many things to discuss about that, from legislation, from all the issues that will come through the sunset review, what the legislature decides. But I think what is more important is that we need to be proactive and have something that is measurable. These numbers are really measurable, and they give greater insight than what anyone may think about what is happening really in the process. It says, no matter how you shake this, the process is not working for the people. The process is not working for the public. But unfortunately, it's working perfectly for the doctors. For any doctor that comes before the board, this system is designed. And they can be I'm done, but I'm really curious to hear from our doctor members about what I just said. If that is alarming or if it's not alarming. Thank you.
Thank you, Mr. Watkins. And I would encourage you to please forward those written comments to all of us. I was trying to take as many notes as possible, but it's difficult to process all of this information during a live board meeting. So if you could forward that to us in writing, I think that'd be helpful. Are there other questions or comments about this? Yeah.
Forgive me, but I do have to caution everyone that they not violate the Open Meeting Act. I did ask Mr. Watkins for that information. He initially said that he would share it and then decided not to. But I know staff would welcome the opportunity to review his data.
So, sorry, clarification on that, Ms. Webb. Can he, he indicated during his comments that he had something written that he would share with us. I think that's what I was asking, that he share. Is he not permitted to share that with us, or can he share it with us and we can also disseminate it to the public?
It would have to be a public document, or he can share it with staff.
Okay.
Well, here's the deal. The information that I did not share with the board was the cases that I reviewed myself. And I will, why I'm separating this out is because I did not want to come into a point where I want everybody to see the big picture, right? I did this in the last 3 days. In the last 3 days, I did it to sketch a picture, because through conversations, I started realizing people do not understand what I'm trying to, the picture that I'm trying to draw. So to hear me saying we're protecting the doctors, what I'm saying is that statistically, it shows you a system that is protecting the doctors. And this information I will share, this information is actually all on the board's website. And this information should be public knowledge and public reporting every board meeting. That's what I've been trying to say. Now, instead of going through a whole hoop, I made it myself. Because from this information, you can actually measure and change things. As Dr. Mahmood mentioned earlier, you gotta have something that we can measure, goals to achieve. So I will forward you this document. I will forward the narrative to it too. I haven't written the narrative. I've got the statistics. Thank you.
All right. Thank you. Are there any
comments?
I'm sorry. Well, I'm sorry. Who?
Dr. Mahmood.
Dr. Mahmood, please.
Yeah. So I have two observations. Thank you, Mr. Watkins, bringing up this discrete breakdown. Number one is, I think we need to make this very clear, and it is in my mind very clear. I'm a practicing physician, but I don't have any sympathy for anybody. My goal, and I'm pretty sure other doctors' goal on this board, is purely and fully protection of the public. And I don't take one single case having any sympathetic feeling towards any doctor or giving any doctor in a benefit of doubt in a way where public can be heard. There are cases where I go on and many other doctors go on, we go on to punish more than what has been recommended. And there are cases we kind of disagree that we need to cut down because we practice this thing, and maybe sometimes when you practice, you see the challenges and difficulties, and everybody will disagree. Everybody will have a little different opinion. What we have done so far, most of those cases go through the board. Either we want to say that this board is deviated or inclined towards professionals or doctors, or this board is biased, or we want to make sure we are making the decisions the right way, because ultimately buck stops at the board members, and discussions are very open. So we can't really say that we are doctors friendly. If there is something in the system or somebody investigation and kind of stuff hang on there, I don't know about that. Number one on that thing. Number two, on early probation termination, I think Mr. Watkins brings a very good point, but I think there should be one more angle needs to be looked at that. If you look at last 100 cases where probation was terminated earlier than what they were supposed to be, and out of those 100 cases, how many people went on and within 5 or 10 years committed the same thing again? Because our goal is also rehabilitation. Our goal is not only to cut heads, our goal is to hold people responsible, do rehabilitation, and bring them back to the community. So if out of those 100 cases, even if there are 10 cases who are committing the same mistakes again, that means we are doing wrongful thing to give them early probation termination. But out of those 100 cases, there's only 1 or 2 cases are there who are not complying, they should be held responsible and we should continue the process. So that number needs to be really looked into that. People who have been given early termination of probation, how did they perform in next 5 or 10 years, and that data also can be looked into that. And I think in next meeting, the data should be brought on and we should look into that. And if the data is strongly in favor of that, those people are doing an habitual things, then we need to really work on to get on this thing that people should not get, or term limit for the early probation application should be extended. But obviously, our goal over here should be only one, and only one, that is protection of Californians and protection of public and safety and high quality of healthcare.
All right, so I appreciate the conversation and the comments on these topics. I would like to refocus us because this item was agendized for the public as an update on the sunset review hearing. And while some of these topics came up, I do know that there are a variety of stakeholders who want to talk to us about issues that they're concerned about in the sunset review hearing that have come up, that the legislature has also expressed their interest in. So, I mean, are there other comments from board members on the sunset review hearing update?
Can I clear up this one point and then I'm done on this point? Because this is an important point. That there's misconception that, you know, this is not against, as I proposed it, is that I say this is a systems problem. In the previous board meeting, I brought up that these DAG memos that we receive is problematic for me. And that's just my opinion. Everybody is entitled to their own opinion. But they produce these kinds of numbers. So Dr. Mahmood, just to address something you said, that, you know, we push back. But that does not show up. In last year, for example, of all the stipulated settlements that the board, that we were presented with DAG memos, out of the 303, 299 was signed off by the board, a literal rubber stamp. 299 out of 303 is 99% that we didn't make one change. We had a say in it, we spoke about it, but when it went to a vote, it went one direction. And when you see those trends, then it points to, hey, what can we do different? This is not for me attacking the board. This is just me asking that we need to look at these things with a point to identify exactly what it is that we need to do in order to resolve it. Thank you.
Thank you. Are there any questions, comments from board members before I invite the public to comment? All right, seeing none, Sean, would you open the line for public comment, please?
Yes, we've got the Q&A window open and also able to click the raise hand thing if you'd like to make a public comment about this agenda item. First up, we have Sandra Perez. Sandra, are you there?
Yeah, I'm here. Sandra Perez again from Hesperia. I want to speak specifically to a question that Mr. Watkins asked regarding the PTLs. And that question was, how did we get here? My understanding on the BPC 2052, and let me preface this by saying I am no way a lawyer. I don't practice law. I do not have a law degree. But over the last couple of years, after the egregious medical negligence that my daughter faced, resulting in her death, I've learned that BPC 2052 indicates you cannot practice medicine without a valid license. And prior to 2020, the postgraduate training authorization letter was only issued to international graduates and not US graduates of medical schools. And I have two statements here from the medical board, signed by chiefs of licensing of the medical board. One dated February 24th, 2020, signed by a Marina O'Connor. The other one, June 8th, 2018, signed by April Alameda. And both of them, I quote, "The issuance of a PTL will allow residents to train without violating the law," end quote. This means that the medical board and the state legislature knew that residents that graduated from US medical schools were violating the law, and thus they instituted a PTL license for them, so they would no longer violate that law. I think Ms. Webb was a little bit dishonest or less than forthcoming when she was answering Mr. Watkins' question regarding how did we get here with regards to the PTL. Thank you.
Ms. Webb, I just wanted to ask you for a clarification because my understanding is that in the past they were being granted the unrestricted licenses as opposed to these PTLs, but maybe you could clarify.
Yeah. Prior to January 1st, 2020, those individuals in approved postgraduate training programs were authorized by the law to practice while they were in those programs. They did not require a license if they or a postgraduate training authorization letter if they were graduates of US or Canadian schools. The law specifically allowed it. What the PTL did was because they were going to be practicing for a longer period of time without a license, and because we wanted them to be able to moonlight with approval of their program directors and bill and sign death certificates and birth certificates, the postgraduate training license was instituted. That requires them to get that license within 180 days after enrollment in a postgraduate training program. So the law allows for a specific exemption period, and even now, what they have 180 days to get that postgraduate training license. So between day one and the time they get that license, they are practicing within their programs legally because they fall within that exemption period.
And that exemption period's built into the law, correct?
Yes.
Yeah. Okay. Thank you for that clarification.
Ms. Lawson, can I give a little more clarification on that too? So one of the issues that our board faced was that some of these people were not given a second year training. So they were actually did internship and they could get full license. So that was very concerning to the medical board. So that the Cleanup Act, which was done, and same for the international graduates, if they did 2 years of training, could be both internships. Then they were given full license. So to correct that came in the PTL where they are under the institution supervision because they're actually residents to be able to do it. And I can see the problems because of 3-year requirement, but the not all the reason was just only whether they went to school somewhere and whether they went to school somewhere else. It's the one of the bigger reasons was that we thought it was not safe to give somebody full license to practice medicine with 1 year of training
Right.
after medical school.
All right, I'm going to ask that we go back to the public comment queue, and then we can have this discussion once we bring it back to the board after hearing public comments.
Okay, next up we have Eric Andrus. Eric, are you there? Please go ahead. 30 seconds remain. Thank you for your public comment. Next up, we have Dennis Cuevas Romero. Dennis, are you there?
Yes, I am. Thank you very much. Good afternoon, members of the board. Dennis Cuevas Romero, legislative advocate with the California Medical Association. I want to thank the board and staff for continuing to engage on this critical PTL issue, which is causing various challenges, as has been outlined by our joint coalition letter since its implementation. I'd like to focus my comments on the PTL's access to care, as other colleagues will comment on other issues. Many facilities rely on additional support from residents to provide care. This limits the amount of patient access provided to needy communities, especially in rural and underserved communities. At a time when the state is struggling to meet demand for care, policymakers must quickly and swiftly address issues limiting access to care. Additionally, CMA is concerned with the added administrative burdens of attendings to fill the void caused by the PTL implementation issues. While the death certificate issue has been resolved, there are still outstanding issues which are preventing residents from signing disability and employment forms. As board members, you have a keen awareness and understanding of how vital these issues are and the challenges facing residents. We ask the medical board to urge the legislature to resolve these critical issues in statute through the sunset review process so we can eliminate these challenges to access to care while maintaining patient protection. Thank you.
Thank you for your public comment. Next up, we have Katrina Reyes. Katrina, are you there?
Yes, I am. Thank you. Good afternoon, board members. Katrina Reyes with the California Academy of Family Physicians. We, along with our coalition partners, sent a letter to the board outlining our concerns with the postgraduate training license. We'd like to highlight one of the issues we outlined in the letter, which is that the new licensing timeframe has a disproportionate impact on residents who take medical or family leave, particularly on female residents who choose to start families during this time in their lives. California's strict requirement that medical school graduates complete a minimum of 36 months of postgraduate training with 24 months of continuous training in a single program does not allow for the licensure of residents who have taken leave for family or medical purposes without extending their training. Extending training, even though the program director and clinical competency committee has signed off on the resident's ability to practice autonomously, has a domino effect of consequences. We, along with the American Board of Medical Specialties and the American Board of Family Medicine, met with medical board staff in December of last year to raise these consequences. However, I am assuming because of the precise requirements in statute, the medical board does not have any leeway in interpreting the statute in a way that allows for leave without the need to extend training. As a result, we have heard from program directors that residents had to change career paths because of their inability to get licensed in California. For example, a program in an underserved community was expecting to hire a fellow from out of state who has been in excellent standing throughout her training. But because she did not meet California's strict time requirement for licensure due to her partner's serious health condition, and because she is unable to extend her training due to the fact that the program does not have the funding for the additional time, she is unable to be licensed in California and is now seeking employment in other states rather than coming to serve in one of our underserved communities. We understand the medical board's desire to ensure the competency of physicians. Nobody is more committed to this goal than residency training programs and the directors of these programs. It is important to note that clinical competency committees and directors of residency training programs conduct ongoing evaluations of resident progress and ultimately a final determination of resident preparedness for autonomous practice. To Mr. Watkins' point, it is important to consider whether the new licensing timeframe really addressed the issue the medical board was trying to solve. As such, we ask the medical board to work with the legislature to fix the licensing timeframe provided for in statute through the sunset review process, and to resolve it quickly to ensure that we do not exacerbate the primary care workforce shortage in California and access to care. Thank you.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Thank you. I would like to again thank Mr. Watkins for asking questions based on the statistics. This is what we advocates have been trying to do for years, which is using the voice documents to show that the public is not being protected. This is an issue that time and time again, dangerous doctors get the chance to harm again. Take the case of Dr. Arjang Naeem, an obstetrician. He was found responsible for the bleeding death of a woman following a C-section, and he had two other near-miss cases a month before this case and a month later, in which women coded in the operating room while undergoing C-sections. 2 near misses, as well as the death of Kara Johnson. Naeem had a total of 6 harmed women, yet he was just given 4 years probation for all 6 cases. The disciplinary guidelines say the minimum should be 5 years probation for gross negligence. How are cases like this protecting the public? These are cases that haunt us and should haunt the board. You just can't paper shuffle with that kind of harm. I agree with TJ that the board must reevaluate how it is disciplining dangerous doctors. And regarding how you communicate with complainants and the Sunset Review, you don't, and you often lie to us about our complaints. I was lied to by my investigator who promised me an accusation but quietly brokered a PLR without telling me. She then told me that the DA's office was short-staffed and it would take a while before the PLR would be posted. I contacted the DA's office and was told that not only does the DA not write the PLRs, but the DA's office was not understaffed. This board is not honest with complainants and was not honest with the Sunset Review hearing. You are failing the people of California by continuing to give more concern to doctors and their practices than you are to the consumers of California. Thank you.
Thank you for your public comment. Next up, we have Tim Madden. Tim, are you there?
Yes, I am. Thank you. This is Tim Madden, and I'm representing the California chapter of the American College of Emergency Physicians. We are also one of the coalition partners that sent in the letter outlining our concerns with the PTL. I'll focus my comments on the PTL issue with the X waiver. For emergency physicians, the X waiver has become a common and important tool, allowing them to start patients on buprenorphine for the patient's addiction challenges. When applying with the Federal Substance Abuse and Mental Health Services Administration, or SAMHSA, residents are told the following from SAMHSA, and this is a direct quote. To apply for the buprenorphine waiver, you need to have a full medical license that states you are a medical doctor. We will need to withdraw your waiver as you do not meet all the requirements. California emergency medicine residency programs have tried speaking with SAMHSA to explore different approaches to allow for the X waiver, but they have been consistently sent the same message. Unless the physician has a full medical license, they will not get an X waiver. We are also beginning to hear this as an issue in other states. Specifically, the Massachusetts chapter for the emergency physicians just this week told us they are experiencing the same problem and are considering running legislation to fix the problem. We appreciate the comments by the medical board members and staff during the Sunset hearing about their willingness to fix this issue. We also appreciate in the background materials the medical board reaching out to SAMHSA, but would note the lack of response and follow-up from SAMHSA. Given the stance of SAMHSA, it is unclear to understand how to fix this problem without going back to the structure before the PTL was put in place. We appreciate your time and consideration of our comments.
Thank you for your public comment. Next up, we have Michelle Montserrat-Ramos. Michelle, are you there?
Yes, I am. I am Michelle Montserrat-Ramos, and I'm with Consumer Watchdog. Regarding board composition, staff has recommended to add 2 additional members of the public, and you have not considered a possible change to its composition. Please change the composition of the board to ensure some form of consumer protection. This current composition of physician majority is not working. Give the public members the vote they need to protect the public. Consumers are not being protected. Cost recovery. Yes, consumers agree with the board. Please seek the authority to seek cost recovery. You will regain some funding. It will decrease enforcement timelines and will lead to more accountability for patients and consumers. Complaints. No, families are not being advised of their complaints and are not receiving letters of their complaint status and where they are at in the enforcement process. They are not being notified that their case is formally under investigation with no investigation numbers. Families are hearing of the outcome of their cases by members of the public and not from you. An investigator has told one of my families that you are no longer providing letters to families. That is not what you are telling the legislature. It is unacceptable to mislead grieving families. Enforcement options. You should not be looking to cut enforcement costs on the backs of Californians. A letter of advice is not a cost saver. It will lead to more deaths. Consumers are completely against a non-adversarial manner of resolving disciplinary actions. consumers are completely against a letter of advice. You may issue a letter of advice to a communications tech who does not repair your Wi-Fi or cable issues, but there is no room for a letter of advice for a doctor when it comes to a life lost or a Californian who now has to endure life in a wheelchair for the rest of their life due to negligence. There is no place for a letter of advice when it comes to a doctor and the fragile life of a patient. This does not protect the public. It protects the doctor and leads to more lives lost. Thank you.
Thank you for your public comment. Next up, we have Hannah. Hannah, are you there?
Yes, I'm here. Yes, can you hear me?
Yes, please go ahead.
Okay, I apologize. You know, it's interesting. I'm working with the Hawaii Medical Board, and they meet at the exact same time as you all do. So I apologize for that confusion. So yes, I just wanted to state that Dr. Mahmood, I agree with you. So doctors are rehabilitatable. I've seen it. I've experienced it. So no one is perfect, of course, and there is evil out there, but we at Black Patients Matter are very grateful for the strides that have been made with the Medical Board of California. And I know that everything takes time and it's a process. So I commend you and I encourage you to keep pushing forward because we are going to change the country. We here at California. So thank you very much for your efforts. That's all. Thank you.
Thank you for your public comment. Next up, we have Helena Papa. Helena, are you there?
Hello. Can you hear me?
Yes, you can. Go ahead.
Okay, thank you. This is the first board meeting that I've actually spoken at, but I have been following these board meetings. I am one of the cases that the Center for Public Interest Law featured in their Sunset Review letter. So I'm very frustrated, I have to say, with what I've been hearing over the last year and a half of listening to board meetings. First of all, I do not think that the board members really understand what is going on in the enforcement process. I appreciate that there are some really good probing questions being asked. I think Mr. Watkins is asking excellent questions. Thank you very, very much. In order to, and I'm mindful that I cannot talk about my individual case because it's active. You must audit individual cases in order to find out where the process is breaking down. And that doesn't seem to me to be happening. There were breakdowns in my process because my complaint was actually reopened. So it was significant enough for it to be reopened. So there was an initial failure with the initial medical expert review. I have not been getting communications that are being represented by the board members that you're giving out to the public. I have not been, I call very frequently to find out, and it's very frustrating that I have to keep on it in such an aggressive manner when my case was important enough to be reopened. So the letters are not going out at every stage as you are representing on these meetings. The complainants are not being kept in the loop. Right now it's an investigation. I cannot get any information about what's happening in the investigation process. I still have not been interviewed. I have given so much, I am a trained lawyer, so I have given the information in such a detailed fashion to them, almost spoon feeding them the case. I cannot understand why I have not been interviewed or the doctor hasn't been interviewed, and her interviews have been postponed twice already with no explanation to me. And now I'm in the situation of wondering if my statute of limitations is going to run. So I think these are things that I just want to raise. I do think you need to audit individual cases such as mine to find out what's really going on. Thank you.
Thank you for your public comment. At this point, Ms. Lawson, I do not see any additional questions queued.
Thank you, Sean. I will bring it back to the board. Are there any additional comments or questions on this agenda item, which again is the Sunset Review hearing update? Dr. Lewis.
Yeah, I just want to remind some of the members of the public, one in particular made a comment about doctors not being, our mission does not deal with rehabilitating doctors, but the ALJ's comments at every one of the meetings I've attended in panel A do refer to the fact that protection of the public is paramount, but also we do not punish. We try to rehabilitate when possible. And if that individual in the public would look up in Google about the medical board and about the laws dealing with discipline of doctors, that person will find those comments in there. Thank you.
Any additional comments from board members? All right, seeing none, we will move on to agenda item 9. And just for an update, I'm planning to take a brief 10 or 15 minute break before we go into the item 10, which is going to be a lengthy discussion of legislation. So I was planning on doing this item 9, and then we'll take a 10 or 15 minute recess before we sit down again for a lengthy discussion of all the legislation. Can I just see some heads shaking if that sounds good? Great. All right, so we'll move on to item 9, an update on the public stakeholder meeting. And Mr. Pasifka, this is yours again.
Okay, thank you very much. I hope this will be relatively brief since I think a lot of material here we have already covered. As was stated, there was a public stakeholders meeting on the 21st of April, 2021. It's the intention to hold these on a quarterly basis, effectively between board meetings. We had over 80 individuals participate, or close to 80 individuals participate. On the board, president and vice president, along with 5 other additional board members, were present, as well as lots of staff of the board executive. We invited Bridget Grammy of the Center of Public Interest Law to speak. The Center for Public Interest Law has a long history of interest in the medical board. They have published a number of reports going back a number of years, and so we thought that she was a very good speaker to bring with us. One of the major themes that has developed, and we've already spoken about here, is the issue of transparency. But for me, the most important result of the board is that the executive, along with the president and vice president, have developed an action plan that is going to arise out of the public stakeholders meeting. We are currently working to develop a video to explain the complaints process. We want to refresh the website to give more information about the complaints process. As we have said today, we are looking to enhance direct communications and contacts with complainants. We have been actively measuring that. We've been monitoring it. We will be looking for more milestones in which there will be communications. As was already stated, we're looking at an ICT project so that we can create an online tracking mechanism that complainants can use. We've begun the process of looking at other jurisdictions, which we have stated the Ohio Medical Board, the Maine Medical Board have respectively victim coordinators and consumer advocates. We would welcome our stakeholders to do a similar trawl of other types of organizations that have this sort of liaison between the board and the complainant that is a useful model whereby we can make it more user-friendly and communicate more directly with complainants. We're going to be reestablishing the Public Outreach, Education, and Wellness Committee, and the goal is to engage further with the stakeholders at subsequent meetings to brief them on the progress that has been made to date and to get further suggestions, particularly on how we can work on this transparency issue. And just in conclusion, I note that transparency and communications was a major theme raised by 4 of our board members at the recent Senate Rules confirmation hearings. We look forward to working with you in particular to make our communication, outreach, and complaint interface more effective. So we'll be happy to answer any questions on that.
Thank you, Mr. Pasifka. And one thing I will just add is that I really appreciated about the public stakeholder meeting was the opportunity to have a conversation with our patient advocates, with the other stakeholders who were present at that meeting. And when I say a conversation, I mean a real back and forth where we could speak to each other, because the process that we have for our board meetings, because of the Open Meeting Act, because of the agenda restrictions we have in terms of accepting public comments and really not having a conversation during these more formal meetings, really limits our ability to just have a human-centered experience, really, and communicate on a human level with those who are so interested in the work that we're all doing. So I hope we can continue these meetings. I hope perhaps that maybe even the next one or the quarter thereafter, we can do it in person. I envision the type of thing where you all sit around a table. If we have 80 of us, it's going to be difficult to have it in that format, but the type where really we can interact with each other and work collaboratively to come up with solutions to the to the problems we have. And I see them as opportunities to improve the work we're doing. And like I said, I thank all of the public participants in that stakeholder meeting. I thought it was very valuable. Dr. Yip, I see your hand up.
Yeah, I would like to request possible we can fix a day way ahead so that more people can attend. Particularly now for myself, after the pandemic recovery, we're short of staff in the hospital, more patient needs service, nursing staff is short. We really pretty hard to provide service to the public. So I'd love to really have a meeting with the stakeholders. So we can even do it evenings, like 5 p.m. After hour, we can schedule a lot better and more board members can attend. That'll be great. And also fix the date way ahead of time. That'll be wonderful. Thank you.
Yeah, thanks, Dr. Yip. And the comment about timing, in fact, the executive leadership and I had a conversation about even rotating the time, right? Because the time isn't going to always work for everybody. So just like we rotate our meetings sort of around the state again to, typically we travel around the state much in the same way, rotating the times of these meetings so we capture as many people as possible, recognizing that not everyone is going to be able to make every particular time we set for various reasons. Any other comments from board members?
Randy, may I speak?
Dr. Hawkins?
Yeah, hands up didn't seem to be working. So it's clear from that stakeholder meeting as well as today, we have a lot of work to do with our Public Outreach, Education, and Wellness Committee. As sooner we can get some dates for when we might meet, the better, so folks can plan, as was just mentioned. The advocates have told us they don't want to be involved in meeting planning, and they've made some other suggestions like advisory committees. We want to work, and we will work with the public to make this work. I'm not sure it's going to be easily. We have things that get in the way, like Open Meeting Act, that we can't control. But there's a commitment from me as the chair of that committee and 2 other members, Ms. Campoverde and Ms. Lubiani, and I really know the board as well, because it is not working the way it needs to. Although they don't know about this, I don't wonder if, because we haven't had a chance to talk, Ms. Lubiani and Ms. Campoverde, would you mind speaking anything you thought about regarding this committee? I realize we're behind, but perhaps you can say something if you're inclined. If you're not, then I apologize. 2 other members of the committee.
Sure, thank you. Lori here, if I may.
Please.
Thank you. I think overall, I'm excited about the progress we've made. And now that our committee is, we're planning to convene and just, roll up our sleeves and get to it. But also, think of prioritize the work we have to do and think realistically, what can be done in what period of time. So we're going to take a look at that. We'll look at the ideas that have come in, bring some of our own, and looking forward to it overall. Thank you.
We have a lot of tools at our disposal, thankfully, because of every kind of platform, from podcasts to social media to our website to our handouts, and brochures that haven't been updated in a while. So there's a lot of things that we can do to improve our communication. I know that all three of us are really excited to roll up our sleeves and look at how to do that in a way that's culturally competent, inclusive, and is able to explore new ways, again, to pull back the curtain on the process so it feels less esoteric and be able to all feel like we understand what's going on. So feedback and the back and forth is going to be really important in this, but we all are really excited to dive in. That was, as was mentioned, something that we talked about in our confirmation hearing, and we all want to prioritize.
I have a comment. This is TJ Watkins.
Please.
So we are on a great first step, and I feel the energy and the new excitement of the new committee, and that just makes me feel like we're going in the right direction. Here's my suggestion. We are taking people on a journey, so the expectations have risen because we've created space for them. So I would like us, and I think Ms. Ljubljana pointed to this, of prioritizing what are the things that are the most difficult, what are the things that is in the medium term, and what is the low-hanging fruit that we can immediately start giving back to the people that have approached us. Because how this relationship is going to work is like every other relationship. Someone asks for something and they expect something in return. They either expect an action or they expect that you need to communicate with them. So we are really going to be called to order right now, because some of it is going to be difficult. I mean, some of it is going to affect the laws that we have to abide by. We better have a game plan to make sure that when we communicate with them, we say we've reached that point here that it's going to affect a certain law or whatever, so we can't really touch that at this stage. But we are doing X, Y, and Z at the bottom, at the low hanging. Simple stuff like including things on this agenda, for example. Someone mentioned that. If it doesn't take much, let's do it on a shorter time frame. Because now that we have a little good start, we gotta feed momentum into the system. And that's just my suggestion, but this is encouraging.
Thank you,
Just to add to the points made, and there's two different kinds of communication and outreach. There's responsive and there's strategic. And so we have to do both sides, right? There's the kind of communication that we strategically push out as a board, again, that we have control over those platforms and the new platforms that we're creating, like the web tracking system, which obviously a lot of people are very interested in how that rolls out. And then there's a responsive communication, obviously these letters that people don't feel like they're getting, and that kind of communication. And so both sides are very important and have to work in tandem with each other.
Additional comments or? All right, seeing none, we'll open this for public comment, please, on the public stakeholder meeting.
Okay, the Q&A window and the raise hand function have been activated. If you'd like to make a public comment. First up here, we have Eric Andrus. Eric, are you there? Please go ahead. Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you. I would like to also say that I found the public stakeholder meeting to be exceptionally remarkable as far as this kind of a board meeting is concerned. The fact that there was indeed conversation around the issues was very refreshing. And as a public commenter, I felt that I had been heard. In that respect, I would like to encourage that, although I am definitely looking forward to in-person meetings, because some of the people I represent who suffer from intractable pain and have less than optimal care at this point find it difficult to travel, to drive. I would like to suggest that you retain the option of attending virtually if that's possible. I think that would be helpful to a lot of the public stakeholders. I thought that Mr. Pacifica's report was comprehensive here, except in one regard, and again, this was your first meeting, it's your first staff report, but I did feel that my comments about the urgent need to restore access to medically managed care for intractable pain patients, because it did generate what was surprising to me, some additional comment and discussion. I've gone back and listened to the recording and saw that it was like 20 minutes in its entirety. I very much appreciated that both Dr. Krause and Dr. Thorpe had some substantive comments, and that Ms. Lawson, you indicated, you informed me of some of the board's plans for the future, which was very helpful. I would have thought that perhaps that would have risen to a level that it would warrant a mention in this report, and that was a little bit disappointing to me. Finally, I would indeed agree with Mr. Watkins that people who have urgent issues of great consequence, access to appropriate care for people suffering from the worst kinds of pain illnesses, we do feel a sense of urgency, and we do hope to get some answers and action. And I believe there may be a way that the program I have outlined for this small, very small group of tragically ill patients might be looked at as low-hanging fruit, and maybe there's a way to get there. Thank you to all of you. I do encourage and hope that these public stakeholder meetings continue. I thought it was very valuable, and I appreciate the opportunity to comment. Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I am pleased that you're willing to implement my recommendation that I've been asking you to consider for years, and that is to create a video on how to file a consumer complaint. Consumer Watchdog is very interested in seeing this action through to completion. Please utilize the medical expert training materials that is already in your possession. These materials will give consumers the specific information they need to file their complaints that will address exactly what you're looking for in a complaint. In the past, board members have stated that they had to dismiss viable complaints because they did not have the information they needed. Giving consumers information you need will help you and your enforcement staff, and that information is in the medical experts training material. We're also pleased to see that you're willing to create a complaint tracking system. The complaint tracking system is really simple. Dr. Yip came up with the idea first. Model it similar to Amazon's or the post office's package tracking system. The family has a tracking number included in their initial correspondence with the board. The tracking system will tell them that their complaint is with a CCU analyst or it's with a medical consultant. A medical consultant has closed the case or has been referred to a field office. It is with the investigator, it's with a medical expert, etc. Please make sure that it includes tracking through the entire enforcement process and not just the initial stages of enforcement. Thank you.
Thank you for your public comment. Next up, we have Helena Popovic. Helena, are you there?
Hello, yes, thank you. I think the video would be a great tool. I would have appreciated something like that. I did give very comprehensive information when I filed my complaint, the one that I was referring to earlier that had to be reopened, was closed prematurely and was reopened. In my case, my understanding was the information I provided was actually not looked at. So it was there, but not looked at by the expert. That's my understanding. but I do think that a video is required. I have a background in law, so I know the kind of information someone would be looking for, but another person who doesn't have that background wouldn't know what to provide. The other thing I want to bring up is there's I don't understand how the public letter of reprimand system is actually serving the public. There was one doctor that I was trying to look up. This was all in connection with my case because there were some interrelated cases. And I called the medical board and asked specifically why a doctor had been reprimanded. And I was told by the enforcement analyst that he could not tell me. And I said, well, I don't see how that's protecting the public if the doctor has actually had some kind of discipline and you're not telling me any information. And he, just was very dismissive of my concern. I ultimately did find out because I went to the courthouse and looked up the case that led to the public reprimand, the malpractice case. And there were some very concerning information within that court file. So I don't really understand that was a negotiated settlement, and the doctor pushed to have that information taken off his public reprimand file. So I just want to bring that up because I don't think that the public should have to go to the courthouse to try to dig up a malpractice lawsuit to find out exactly what happened in a case. That's all I have to say.
Thank you for your public comment. Next up, we have Hannah Reed. Hannah, are you there?
Yes, I'm here. Yes, I just wanted to just state that I think we're making progress here at the California Medical Board. I just got off the call with the Hawaii Medical Board, and my hope is that whatever progress we make here, that it would be picked up by the other medical boards in the country and utilized, because we have to, as Mr. Persifka had stated, we have to rebuild the relationship between physician and patient, and that many times the patient just wants to know what happened and wants a line of communication. So thank you so much. That's all.
Thank you for your public comment. At this time, Ms. Lawson, I do not see any additional requests.
All right, thank you. Sean, are there any additional comments or questions from the members of the board? All right, seeing none, I have 5:49 as the time. Could we plan to return at 5 after 6 o'clock for agenda item 10, which is the legislation agenda item? All right, we'll see everybody back in 15 minutes. Thanks very much.